With your lordship's kind leave, may I mention a matter, have a short reverse.
Yes.
And it is really 11th time I mentioned that.
What is the
Content matter passed by your lordship's order. Let it appear. I have to come with your lordship.
আড্ডি ডেটটা লাগবে, আড্ডি অন ডেটটা The date is necessary. Maybe that's why it's not coming. The date is required.
Yes, it's required.
My lord, may I be permitted to mention two matters for upgradation? The urgency is that this is relates to unauthorized enforcement made by the private respondents. Therefore, the petitioner is facing great difficulties.
Huh? Did you mention on Monday? Monday is monthly list day. It's mentioned on Monday. Otherwise, it will not get into the monthly. It's difficult. It will be difficult.
All right.
Mentioning one matter, my lord, for upgradation, my lord, this matter is
You
item
heard
number.
just now what I've said.
Monday upgradation
Monday is
is on
monthly
Monday.
list day. So why don't you mention on Monday so that I can fix on Tuesday onwards?
Right.
Because otherwise, it will all get into the monthly. It will be difficult for you, isn't it?
I have a different prayer sort of this. But yesterday, item number 11, contempt application, my lord ordered direction for, upon the alleged contempt. My lord, now from the date of filing till yesterday, the new incumbent has come in. My lord, I could not serve, my lord. Yesterday only service was available. If my lord, the matter can.
So to add the new incumbent
Yes,
as an alleged
only for-
contender.
to be mentioned for only for that purpose.
But the same thing, you know, it will get into the monthly.
You, my lord, I will come back on Monday. Yes, yes.
I'll take care of this.
Yes, my lord.
What a pain.
My lord, one indulgence after taking consent of all other Senates for joint prayer. It's a matter of state of Assam where, my lord,
Yes, yes.
my lord, in your lordship's record, matter is due to appear on 16th of January. In our record, it is also on 16th of January. But in the order sheet, typographically on 15th. Well, just let it be corrected. Nothing else.
Correction of-
Nothing else. My lord, only just I'm praying for this one, my lord.
Why don't you mention on Monday, please? I'll take it. Tuesday I'll do it. Please mention on Monday.
My lord, my difficulties, my lord, they will not be here, lordship. That's why I am saying,
Not be here.
well, that state advocates of state of Assam and other parties. Well, it's just
Mention on Monday. You should not get it.
for 60. Nothing else.
My lord, I have
Nothing else. Lordship.
I was praying for upgradation, my lord. I will come on Monday, my lord, subject to my lord monthly list item number.
Please come on.
Yes,
Yes,
great.
Otherwise, it's difficult for you.
Yes, my lord.
Yes.
Great.
Yes, call the days list, please. Item 1. The writ petition has been allowed. I'll read out the operative portion. Since the petitioner has prayed for issuance of a formal order of de-requisition in respect of the plots in question by the seventh respondent in view of the fact that both the acquisition proceedings in respect of the plots in question were set aside by this court earlier, and the petitioner has acquired right, title, interest and possession in respect of the same by virtue of purchase, the writ petition succeeds. Land of other owners similarly circumstanced and involved in the same acquisition proceedings has been de-requisitioned/released by the state respondents in their favor, and the petitioner is entitled to the same relief. Accordingly, the writ petition is allowed. The collector under Act 1 of 1894, Howrah, being the seventh respondent herein, is directed to issue formal order of de-requisition in respect of the plots in question in favor of the petitioner within 2 months from the date of communication of this judgment. However, the state respondents are at liberty, I have granted this liberty further,
That is always there, my lord.
to initiate fresh acquisition proceedings in respect of the plots within the aforementioned time frame in accordance.
Obliged to your lord.
I'm sorry, Mr.
Deeply
Narayana.
obliged.
Yes.
Obliged to you.
Chennai.
Item 2,
So I'm for the petitioner in item 2, Lordship. The interim order is expiring on yesterday. The interim order was expired.
Interim order, final hearing ho.
What about the hearing?
Interim order.
Lordship, kindly fix any day. I'm led by Mr. Bhattacharya. Any day, Lordship. Kindly tomorrow, day, Monday or Tuesday. Any day, Lordship. I'll come.
Interim order.
But actually,
Very bad.
I'm willing to.
No, no.
For final hearing. I'm ready for final
You
hearing.
are-
Kindly fix any day.
you are-
Tuesday
interim
or
order
Wednesday.
because
Is
continuous.
the hearing matter?
Yes.
Affidavits are complete?
No, Lordship. Because in one of the connected matter, appeal has been carried out. Kindly consider Lordship's 19th June order 2022.
They will go court. But your specific issue is that they are not being heard, the order was passed. You also relegate this matter.
But impugn order is 7.
Actually, if they are not-
2022 it was recorded in one of the connected matter, appeal has been carried out.
There is an appeal pending, so please do not.
You-
bring all this
My
up.
lord, only for that reason, my lord, your lordship will send the matter to the appeal court.
Yes.
And according, why the
I
four
will send
matter,
the matter to the appeal court.
yes, my lord.
How is that
Appellate
possible?
authority, my lord, there is a provision of, my lord, that is 10-4. So, my lord, that is pending. Only for that reason, my lord, he is taking time.
An appeal is pending before the High Court. not
No,
there.
No, my lord, that is 10-4. If, my lord, High Court, we have not any objection, my lord. That is the 10-4, my lord, if your lordship will see.
Then for the applicable order.
Taking that plea, my lord, every day he is taking time.
There is pending.
Lordship, in one of the matter, it was submitted on yesterday. Lordship, I'm led by Mr. Bhattacharya. May I hand over, Lordship?
Yes, Mr. Bhattacharya.
Now,
Where is
kindly extend the interim order and Lord, as it was done before, till the appeal there is decided, my lord, this will continue and
where
on the
is
basis
the
of the
appeal
appeal,
pending?
in another matter before the appellate authority filed by another person. That's why my lord was kind enough to say till that is decided, this court cannot decide.
There is already an order to that effect.
Yes, yes.
My
Now
lord,
the interim order should be extended.
The
The interim order was for limited period.
My lord, appeal is pending. Only for that he is taking time.
Parties were heard on 19th June 2023. Upon hearing everyone, this order was passed.
Yes.
The matter was sent out of list due to the pendency of the appeal.
But
As
they will
the
not pass to the
Yes,
appeal.
yes.
They will not pass to the appeal.
I will. You.
I couldn't understand.
But
They will
you
not
have
pass to the appeal and they will be enjoying the interim order day by day. That's why you are.
Alternate counsels for the parties. Paragraph, the respondents raise vehement.
My lord, may I be permitted to submit one thing, my lord? Only one matter, appeal is pending. So that matter is disposed of and send the matter to the appeal. The appeal will be disposed of. One matter, there are four matters is there, my lord, 2 to 5. My lord, one matter in which Mr. Bhattacharya is there, my lord. That matter is pending before the district magistrate in appeal, 10-4. That matter may dispose.
No, Mullah Prabhal, he is misinstructed. There is no appeal from my matter, and Lord Lordship will allow the appellate authority to proceed. Let them proceed and decide. That will less the burden of the court. Court was of the opinion unless the appellate authority decides factual decision.
Cover all these matters, I think.
Yes.
The same issue.
Therefore, there was no question of, but there was no stay for hearing the appeal. If the appeal can be heard out, let it be heard out.
Okay, why don't you persuade the district magistrate to hear the appeal, dispose it out? It is your authority. He is sitting over it. Let him dispose it out within some
But
short.
but they will not pass to the appeal. The appeal is pending, they will not pass to. Therefore, they will
The
not pass
state
to.
is also not dealing with the.
He will go, he will go and he-
The appeal cannot.
he will go and energize the appellate authority.
Somebody other demand.
In view of the order transferred back June 9, 2023,
My lord, in this matter, my lord, That is
The
the
matter
petition,
about
my lord,
this.
one thing, my lord. My learned friend, my lord, Bhattacharya submitted before your lordship in his matter.
Matter is not before the appellate authority.
So, my lord, that is his matter, my lord. What is the his matter? Then, my lord, the petitioner is not here, so no extension.
My lord, I am for the item number
I'm for
five.
the petitioner.
I am for the five.
I'm petitioner.
Petitioner, yes.
Yes.
I'm for the
In
petitioner.
his matter, my lord, there is no any appeal.
Mr.
Then
Day
another-
probably is confused.
Mr. Bhattacharya is appearing virtually for the petitioner.
Yes, my lord. In
No, only in
he
respect to
submitted
item number
before your
three.
lordship. My learned friend submitted before your lordship that his matter is not.
This matter is not before the appellate forum.
Only in respect
One
of
of
item
these
That
number
is
three.
that matter. My lord, who is the petitioner for whom that appeal was pending?
Please take necessary steps.
Halim Ali Khan.
The appeal that will
In
solve the
respect
problem.
of item
My
number
lord,
three.
petitioner is not, my lord, all the petitioner is not here. Why extension that matter?
Because it is together.
No, my lord, that is,
Ana-
a-
ana-
that is a person who is.
Respect of
taking
item
a-
number
Analogous matter, my lord.
The interim order granted earlier is extended till 31st January 2024 or until further orders, whichever is earlier. Please take necessary steps for disposal before this date.
Yes, my lord, your lordship fix the
That will
matter.
solve the issue.
Yes, my lord, your lordship fix the matter before, when your lordship fix the matter.
It is extended till 31st January. Please mention about disposal. I'll take it up. Please take a note of it today because the chief minister has to deal with it.
But in this fashion, they will be enjoying the interim order
Next
and
matter.
nobody will be
If you
partial.
are aggrieved, you have an appellate forum, sir. Next matter.
Item 7. Item 7.
আপনার গাড়ি রেখে দাও। On November 28, 2023, paragraph in the said order in the fifth line of the second paragraph of the said order. In the fifth line of the second paragraph of the said order, comma, the words State Transport Authority, comma, Jharkhand, inverted comma, mode, be read as the petitioner. Just change of it. Paragraph, the department is directed to incorporate necessary correction. So, this order be treated as part of certified website. Huh? No, the department is directed to incorporate necessary correction in the said order in the order accordingly. This order be treated as part of the order passed on. Urgent certified website code. Next.
Item 8.
Hello, item number 8 and 9, both.
I appear for the
Appearing
petition.
for the Midnapur Kharagpur Development Authority, my lord. Behind my back, my lord, interim order has been obtained by my learned friend, my lord.
Milord, the petition was moved on to 2nd of August, Milord. Upon service
That
to
is
them,
true,
they
that
did
is
not
true.
choose not to appear, Milord.
But,
Thereafter-
but difficulties, my lord,
Behind your back.
my lord, may I submit one thing, my lord? Within time, the concerned additional district magistrate, who is the executive officer of Midnapur Kharagpur Development Authority, he was not there. Post was vacant. Subsequently, he joined. My lord, yesterday I got the brief. And now, my lord, even I have prepared the affidavit. And only it is to be affirmed. And my lord, thing is that one existing road.
Not here to hear the matter on merits today. It's only for extension. You are not ready with your affidavits today. So let the interim order be extended for a limited period of
Very
time.
short period, very short
Come
period,
back
my lord.
with your affidavit.
Within 1 week, my lord, I'll be filing a affidavit of opposition, my lord. Case is not maintainable.
Affidavits are not exchanged as yet. Paragraph 6, the interim order granted earlier expires on 30th November 2023, comma. The order be extended till 31st January 2024, comma, or until further orders, comma, whichever is earlier.
My lord, the extension of time to file affidavit, my lord, since they,
It's out of place.
my lord, must. And the matter will appear, my lord, in the,
It's out of place.
my
You
lord.
will mention up.
Great,
for
great,
you.
great,
The
great,
date.
great,
Or matters
great.
are extended up to, my lord?
31st
31st
January.
January.
9.
It's mentioned upon.
I shall.
complete. Take it.
But item number 9 is the same order.
Development work has been stalled, my lord. Development work has been stalled, my lord. Government money.
To appear despite service, it will be stalled. Can't help.
It's
Please
true, my
be
lord.
ready with your-
Government lawyer was there, I don't know.
Be ready with your affidavits as soon as possible. It will take. Yes.
My lord, I will send.
I don't know who is appearing for the state. The state also has to file
My
affidavits.
lord, we have served everyone, my lord. They are the answering respondent. 9 would be the same order. My lord, my.
Expired on. Ask your first. Expired.
Item
My lord,
9.
is it possible to extend up to 15th of January, my lord?
My lord, the
I'll
One
take
month.
it up the moment you finish you complete your affidavit.
My lord, my lord.
Liberty has granted you mention.
My lord.
same order, my lord.
Great.
Same order in this matter also.
Great.
Out of Liberty to mention. Liberty to mention.
No. Item 10.
Great.
But I picked up about the petitioner before extension of interim order. And also, my lord, they have filed an report, my lord, before your lordship in this matter. In terms of the previous direction, I want to use an exception to that. This is regarding, my lord, land acquisition under the Metro Railway Act, my lord. I have challenged the order of the appellate authority because interest was not awarded under section 80. This is the point, short point. And they have also challenged, my lord, the order in a separate writ petition. They have also challenged, my lord, they said that the rate should be lower. As per the rates applied by the Inspector General of Registration, that is their case. And our case is that interest should have been awarded under section 80. Both matters may be, my lord, tagged together. I shall use them, my lord.
When is the other matter fixed?
Other matter one,
My lord,
Mr.
I am appearing for Union of India in the other matter, item number 132 in today's list. Let these matters be fixed for hearing together any day after 10th December.
The other matter has not been fixed for hearing
It is in Lordship's list right now, running in Lordship's list, item number 132.
in the supplementary list.
Yes, my lord, in daily list.
It's at the motion stage.
motion stage.
Any day after 10th December, my lord.
Come back after vacation.
After vacation. Huh?
The learned counsel for the petitioner seeks extension of time to use an exception to the report submitted by respondent numbers 1 and 2. Liberty was granted on the earlier date.
My lord, I'm
Paragraph
praying for extension of that.
under the heading motion on 17th January. Paragraph, the interim order granted earlier is extended till 31st January 2024 or with further orders, whichever is earlier.
Much obliged. my lord. The matter may appear 17th
17th.
much-
Item 11.
along with my lord, 19775. Then
Along with the other matter, my lord, item number 132.
Actor line act since WPA
19775 of 2023, my lord.
19775 of 2023 pertains to a similar issue as in this petition, comma. The petition be tagged with tagged along with tagged with this petition.
nice. Much obliged.
No, item 11, my lord, I beg to appear for the alleged contempt. my lord. Lordship kindly regarded, my lord.
My lord, but let me finish.
We have filed our
They have
compliance.
filed an
That's why.
compliance report,
Yes.
which I am denying. I want to file an affidavit in connection with that complaint.
Lordship-
No complaint has been made. My
Kindly,
client
my
has
lord,
not
come to
yet
page
received
38. my
any
lord.
signal
We have
for it.
complied with lordship order.
An exception, let him come back. Where is your compliance?
Page 30, kindly come to page 38 of my compliance report.
Filed earlier occasion.
Earlier question I have filed. There was a lordship was pleased to direct the concerned authority to consider their representation past and rescind order. Order has been passed. Now, what left I can't understand.
Well, what is my grievance? My grievance is my land was acquired. I made an application for getting the compensation, my lord. That has not been done. Against that order, my lord, I have come up before your lordship. Your lordship was pleased to direct to consider my representation
Yes.
within certain time.
Yes.
Hearing was took place, but no money has been.
That is subsequent
yet
cause
been
of
paid.
action, my lord.
No,
Lordship was
nothing.
directed
Why?
the authority to consider the representation past and rescind order. We have already complied with lordship order, my lord. In contempt jurisdiction, my lord, how can you possible?
Has been considered.
Yes.
And
Consider,
rejected.
no consideration has been.
Consider has been
Why
made,
I
my
have
lord.
come
Kindly
to
consider, come to
lordship.
page 38 of my compliance report.
I shall file an affidavit in connection with this compliance report. Your lordship kindly hear out the matter.
Yes.
Stop.
Yes.
By order of,
What
in
is
terms
saying?
of the order of this court. If you are not happy with the observation made in the representation, that's a separate cause of action. The
No, but
contempt application cannot
but-
help you.
Madam, my submission before your lordship, my lord, as the contempt application is pending before your lordship, they have stated that they have complied. So my submission is they have not yet complied because my client has not yet get any compensation. So therefore, your lordship kindly,
Compliance.
so your lordship kindly allow me to file an affidavit.
Let him come.
File an affidavit, my lord. After hearing your lordship, we will pass the
Private
also.
counsel for the applicants / petitioners seeks to use an exception to the affidavit of compliance submitted on behalf of the alleged contender. Paragraph, let the matter appear under the same heading on 20th December.
28th December.
Zero.
As your lordship.
The advance copy may be served upon the.
Yes, yes. I shall serve the advance.
Yes.
I'm grateful.
Item 12.
I am for the alleged contemners, my lord.
Yes.
By an order, my lord, my lord was pleased to direct, my lord, the consideration, and my lord, kindly see the last order passed in the contempt proceedings, that is on 30th of August 2023.
8 or 9, 8 or 9.
My lord, I submitted that they are not being able to produce certain documents. My lord has got the order of 30th of August, my lord.
Yes, yes.
Learned counsel for the applicant's petition submits that such documents shall be produced. No, it is submitted on behalf of the alleged contender that the authority has issued notice upon the applicants requesting them to submit certain documents for.
It's not been produced as
No, not only that, my lord, I have filed an application. My lord, may I just can number 1 of 2023. That's there probably.
yes.
Now, my lord, in that I have, my lord, kindly consider Annexure C, page number 27.
You've asked for extension of the date, isn't it?
I have asked for, and my lord, kindly see one letter written by my lord, my learned friend, Mr. Hajra. Kindly see, my lord, this I am handing over. He has got a copy. It's his own document. They themselves say, in this regard, having prepared their application for submitting the same before and submitted an application, the same under this conclude under I on behalf of the clients request you to give some more time to the petitioners to submit their application for obtaining relevant NOC from the competent railway authority. So this
Before that,
Was on 20th November. just
November.
recently.
but before that, Bharat.
So
Bharat,
problem
in
is-
submission of phase application, I have to, the application should be forwarded by the state authority or local body. I have submitted application before the BLRO for forwarding my application. BLRO is the party in the writ petition. They have served and prior to moving the writ petition. My prayer is, my lord, let the BLRO be added as party contender so that the,
Any direction about the BLLRO in
No.
the petition?
no, but issue,
Who can be added as for contender?
BLRO is the party in the writ petition.
But there's no direction about BLLRO.
No direction. That's why,
He cannot be contempt of the order.
my lord, last, as per their later, my lord,
Application is very technical, I must admit. You are aware of that. The scope is very limited.
no. Yes, yes. That's why I have made the BLRO as party. BLRO,
anyone a party in the contempt application.
BLRO is not a party in the contempt, my lord.
No, BLRO is the party in the writ petition.
Not in the contempt
But
application.
as per their query, I have submitted BLRO. Unless BLRO is forwarding my application, I cannot file my application place. That's why,
Approach the BLLRO.
yes, I have approached. That's why I have written to I already approached. Kindly till the forwarding. Or kindly see the BLRO.
27th September, you've
Yes.
approached the BLLRO.
Yes, already approached.
Any reminder given to the BLLRO in these 3 months?
No,
2.5 months?
nothing. This is my,
Any reminder to the BLLRO? You have just dropped the letter. After that,
reminder. No, I have not given, my lord. But I have informed the authority.
in the contempt application, I cannot ask the BLLRO to do anything. Please approach the BLLRO for
The entire order will be meaningless, my lord. BLRO is the necessary party in the writ petition. My learned friend Mr. Dey is appearing for the BLRO. And the role, there is role to the,
speak to Mr. Dey. Because in a contempt application, you are also aware that the court cannot pass such an order.
but when the order will be in,
Part to it. I understand your plight. I understand what is happening. But please speak to Mr. Dey so that he can help you out. I cannot pass an order. I can only grant time to the alleged contempt. Contempt application has a very limited.
that I know, my lord. But
It's difficult. Speak to Mr. Dey, he will help.
it is their demand that my application should be forwarded by local state authority. State authority is BLRO.
Because
BLRO is the party.
It's not party in the contempt application.
No, there is no direction. I cannot. There is direction upon the.
It has not been included in the contempt application.
That's why I'm.
The court cannot travel beyond the contempt application.
No, this is my prayer before your lordship to add the BLRO party. This is my prayer. I serve. I will serve, my lord. Everything will be solved.
On what basis? BLLRO is not in contempt of the court's order.
No.
So how? How can you add the BLLRO?
Now the issue is pending before the BLRO. Unless BLRO is not forwarded by application, they will not. I am in difficult condition, my lord.
And I find you have just dropped the application and after that no steps taken by you also before the BLLRO.
That I will prayer. May adjourn the matter. I will.
I'll
Vacation was there, my lord, in the meantime.
take necessary steps.
Yes.
Because unless you submit this before the authority, they are not in a position to deal with it.
Yes, that I know. That's why I have informed that I have already made the application before the BLRO. Since the BLRO is not, I am helpless.
It is submitted on behalf of the applicant petitioner. Applicant's petitioner. That the applicants have prepared their application for submission of the same before the alleged contemner. And the same is lying before the Block Land and Land Reforms Officer, Arambagh, since 27th September 2023. Stop. Unless the Block Land and Land Reforms Officer, Arambagh, forwards the said application to the authority, the authority shall not be in a position to deal with the issue. Stop. Paragraph. It is most unfortunate that the Block Land and Land Reforms Officer, Arambagh, has been withholding the application since 27th September 2023 instead of forwarding it to the authority immediately upon receipt of the same. Paragraph. Let the matter, I cannot direct, I am giving it in a roundabout manner.
Yes.
Because the matter has to be solved.
No, we are not standing the kindly see, my lord. We also are, we have.
This reaches,
Oh, yeah,
you are
yeah.
not in a position.
My lord.
I understand.
Yes.
Let the matter appear under the same heading on 15 January 2024. Paragraph, it is expected that the Block Land and Land Reforms Officer, Arambagh shall forward the application submitted by the applicant slash petitioners on 27th September 2023 through the concerned authority being the
Divisional engineer, divisional railway manager. Let's contempt our divisional railway.
manager,
Yes,
being the divisional railway manager, comma, Eastern Railway, comma, Howrah Division, within 7 days from the date of receipt of this order.
Yes.
I cannot direct, I can only expect.
yes.
I may only prefer two indulgences. One is that I have made an application because the time has expired. Technically, my lord, and my lord knows, my lord, the contempt proceedings pending before a proceedings, retirement, everything goes into asterisk. So kindly extend the time. And I have placed a letter dated 20th of November, my lord. Kindly take that on record, my lord, if my lord so pleases. No, later I have handed over 20th November letter I have handed over, my lord. Just I could not, and I have made an application, my lord, because affidavit of service.
Similar order was made on the earlier occasion also.
Yes, but that was limited to that. Kindly see, yes. But unfortunately, that was also,
Earlier one application was filed.
yes, earlier.
Can number one.
Now
This
here
is
also,
also can number one.
yes, because the department, my lord, could not locate the earlier can number one. That's why I have to annex this.
Direction is to comply with the order under contempt within 2 months from the date of receipt of the documents, which you have not received.
Yes,
So it
No,
it
my lord,
remains.
kindly, because
This order dated 30th August,
30th August.
30th August, yes.
the third paragraph. It's covered.
But if at least an application is made, because this, on this matter, I'm sorry to indicate, I have made earlier, the respondent has made earlier an application which is can number one. That application today is not on records. We had to make another application which they have marked as can number one. So something is happening, my lord, by the grace of God. Only thing that I have made this clear, because my lord,
Because you have already been granted so.
yes, no, kindly then record, my lord, that the documents have not yet been submitted. That will also do. Other,
Yes, he admitted.
very good.
And let me cancel this also.
Okay.
Paragraph 2. In view of the observation made in the order passed on August 30th, 2023, comma, the application being can 1 of 2023 is disposed of.
And my affidavit of service be kept on record.
Can along with can CPN along with can. আর একদম last করুন a copy of this order be served upon the block land and land reforms officer
Get.
Arambagh by the petitioner at the earliest.
And my lord, I have handed over a copy of the letter of 20th of November. Kindly, my lord, keep it on record. my lord.
এটা ইয়ে করে
Doctor
affidavit of
Hussain,
service এর পরে করুন the letter dated 20th November 2023 filed on behalf of the alleged contemner is taken away. Affidavit of service এর পরে এটা রাখা কথা। হ্যাঁ। এটা আগে serve করুন। একটা আগে serve করুন। সেটা অনসিপ থেকে 7 দিনের মধ্যে দেন। কি আছে? The order. Orderটি তো serve করতে হবে। কি আছে?
I am also filing the evidence.
Hello.
Along with can.
Affidavit of service কিসের?
Regarding my present incumbent. I am also filing the evidence, sir. Present upon service upon the present incumbent.
Can number one affidavit of service.
Affidavits of service করুন।
এটা
যে নতুন হয়ে গেল।
একটা
ফাইল করেছে? আমার কপি কপি পাই।
Affidavit, sir.
আমরা affidavits of
আরে
service
প্রেজেন্ট ইনকামবেন্ট যে নতুন হলো না ডিভিশনাল রেলওয়ে ম্যানেজার অ্যাড করলাম না কতদিন আপনি বললেন নাম চেঞ্জ হয়েছে সঞ্জীব কুমার
আমাদের কোনো কপি তো দেয়।
আরে
একটা কপি এটা দিয়ে দিন না আপনার না 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 একটা কপি চাইছে আপনার
নাম চেঞ্জ হলো বুঝতে পারছেন
Ajit.
পাঠিয়ে দিলাম কোর্ট
ম্যাম
Please, Your Lordship, I'm for the petitioner. This matter had been heard on a previous occasion by Your Lordship. My Lord, may I kindly hand over the copy of the order that was passed by Your Lordship?
There in the file, I hope.
My Lord, they are. The facts are indisputable, my Lord. I am a Mr. Ganguly.
Mr. Roshan Ganguly, where is he?
On two previous occasions, he had submitted that he shall be taking instructions from his client. If Your Lordship would kindly permit me to recapitulate the facts of the matter, my Lord.
You're asking for execution of a deed of conveyance?
For formal deed of conveyance, my Lord.
KMD.
No, my Lord. I am NSIC. I am a Government of India enterprise, my Lord. The land was acquisitioned in 1960-61 for setting up of my technical services center. In 1970s, I paid the government for about acquiring 4 more acres for building an approach road. My Lord, thereafter I wrote to the government that a formal deed of conveyance or transfer ought to be executed in my favor. Thereafter, my Lord, there was a request from the state government to the central government to transfer 76 acres out of 121 acres that were acquisitioned to set up my institute in favor of the then CMDA. But my Lord, that time I did not have a valid record, so I kept on writing to the government. But there was instructions from the government. There was some notification issued by the Commerce and Industries Department, which was the requiring body. So, my Lord, I gave permissive possession to CMDA. And, my Lord, this letter writing went on and interdepartmental correspondence went on, where the Land Reforms Department was saying, no, Commerce and Industries Department needs to execute the deed of transfer. Commerce and Industries Department sat on it, and then there was so, my Lord, this is a matter of just bureaucratic football, nothing else. In 2004, I was also made to formally transfer the 76 acres to KMDA. My Lord, I have been writing since then from 1980s.
I'll fix the matter next week. Just inform the date to the respondents, and I'll record that even in absence of the respondents, it will be taken up.
Lordship pleases.
None appears for the respondents. Stop, no accommodation is sought. Paragraph, let the matter appear under the same heading on 7 December.
Lordship pleases.
Paragraph, it is made clear that the matter shall be taken up for consideration on the adjourned date, even in absence of the respondents. Paragraph, the petitioner is directed to serve notice upon the respondents intimating the adjourned date.
Great. Great.
14.
This is my writ application, Your Lordship. I'm led by Mr. Basu.
14, I am for the Union of India, my Lord.
This is Substansu Basu, Your Lordship. I'm led
Yes.
by Mr. Basu, Your Lordship. He was here. He just left for another court.
I've just seen Mr. Basu here.
And he was here. He just left for
There is a
another
direction
court.
for submission of report, my Lord.
There is the report in the.
Yes, my Lord.
Lordship, can it be passed over, Your Lordship, or can it be taken up on Monday, subject to Your Lordship's? He was here only.
To use an exception to the report.
Lordship, this report in fact is helping us. They have only given up the records which they are holding, and this report helps me, my lord. There is no reason why my rent has been withheld by them. There is only a single letter, subject to my learned senior friend, Your Lordship. He'll be addressing Your Lordship. There is only one letter by which they have been holding my rent. Your Lordship would kindly come to annexure A54. A46, Your Lordship, at page 58.
Yes.
Before that, Your Lordship would kindly come to annexure A38. this is the joint meeting which was held where the rent was agreed by the parties from 2007 till date. This was communicated to the head office for approval and payment. Your Lordship would kindly see the next letters. Ultimately, Your Lordship would kindly come to A45, Your Lordship, at page 57.
Yes.
The respondent authorities ask for payment to be paid to my clients. The rates are fixed, everything is fixed. There is no reason why they are withholding.
You want to come back?
Lordship would kindly, I would be requesting, Monday, Your Lordship, first thing will be here.
Monday or Tuesday, my lord. Monday.
Lordship, keep it Monday, Your Lordship would kindly. My clients are in, because we are facing criminal proceedings, Your Lordship.
There is, they are getting rents, but they are
They are not
they are
getting,
asking
Your Lordship.
the enhanced rate that is exorbitant. The amount is very much
They have
exorbitant.
agreed.
Cannot be.
Agreed by the parties
Part
and
No,
of
my
the
lord,
agreement,
no,
Lordship.
that is not agreed. That was agreed to send for approval. And the head office did not approve.
But
But
it is agreed upon.
no, my lord, I have no right to fix the amount. The head office is the right to fix the amount. And I shall also in the report, my lord, so my lord, there are other rented accommodations which are very less than what they are expecting, my lord. Their expectation is a very exorbitant amount. And lordship, there is also fair rent by my lord,
7th December.
7 is lordship.
A report in the form of affidavit submitted by the fourth respondent is taken on record. Paragraph on prayer of the petitioner, petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 7th December 2020.
Obliged, Lordship.
15.
I am for the petitioner, my lord. In this matter, my lord, the land of 10 decimal of land was acquired in the year 1976. And after 14 years, the notice was issued in the year 1990. And thereafter, my lord, they did not give the award. Several representation was made. But being aggrieved, the writ petition is preferred and writ application before this honorable court. And honorable court was pleased to direct to pay the entire amount, compensation amount to the petitioners within 4 weeks from that date. In the year 2006, the Honorable Justice Jayanto Vishwas was pleased to pass the order, but they did not pay that amount. Even they did not given the award also. And thereafter, in the year 2010, they passed an award, and thereafter we preferred an application before the district judge, London district judge, for enhancement, and they did not enhance the amount intact. In the meantime, in the year 1997, Amendment Act as Amendment Act 1997 Amendment Act appeared, and that Amendment Act prevented all notices under Section 9(3)(b) of the said Act if award had not been passed within 3 years from that date. So after elapse of 1990, the notices issued, and thereafter they passed the award in the year 2010, much after 20 years. So within 3 years, they did not pass the award. So that act already been non-A. That is not cannot be applicable. In the meantime, 2013 new act is also applicable. So I prefer this application for direction may be given for to the respondent authorities to pay the entire amount after after issuing the new notice. Fresh application.
Yes, Mr. Bangam.
For the land acquired under Act 2 of 1948, my lord. That at that point of time, my lord, award declared, notices were, my lord, issued to the petitioner for receiving the payment of compensation. They have turned up.
Award declared within the statutory period.
Yes, no, at that point of period
They
of
have
time, my
not received the compensation amount. Thereafter, they preferred an application reference case. No, sorry, my lord.
My lord, they have not much turned up to receive the, my lord, compensation amount, my lord. Thereafter, my lord, we have deposited the said amount, my lord, under Section 30 with the, my lord, district court, my lord. District judgment.
Have the documents with you?
Yes, but we have solved all the, if your lordship directs me, we have received the, my lord,
Let them come
report.
up with a report in the
There are
form.
several
That
things
will
which
be
are,
later, my lord.
They
The
say-
first case has been, my lord, filed, and the judgment and decree has been passed to that. Therefore, no matter how the repetition is maintainable, my lord.
No,
Yes, there is a section 18, my lord, the application and judgment. and
well,
decree has been
they passed the award in the 2010.
There is a
They cannot
constitutional
deny that
section,
award. They cannot deny. The
Yes,
after
but-
elapse of, after applying the 1997 Act, they cannot pass the award after elapse of 20 years. They passed the 2010.
passed, my lord, which
So
is in
that
time, my
act
lord.
has not,
They have not received the amount, my lord.
State
No,
says
no.
otherwise. The state
Yes,
says
madam.
that award was passed within the statutory period.
Yes,
my lord.
long back, my lord.
So let them
The
come up with the
statutory-
report, let them show the documents.
yes, ma'am.
Yes.
Submitted on behalf of the petitioners that
Yes.
no acquisition proceeding in respect of their land was initiated under the West Bengal Land Requisition and Acquisition Act 1948. Award was not declared within the statutory period of and as such, the acquisition proceeding lapsed. Paragraph. For contra, learned counsel for the state respondents submits that award was declared within the statutory period of time, and despite service of notice to the awardees, they failed to appear before the authority for receiving the award, for which the amount was deposited before the district court under section 30 of the West Bengal Land Acquisition Act 1894.
Yes.
Learned counsel seeks to submit a report in the form of affidavit in this regard, annexing relevant documents.
Yes.
Paragraph, let the matter appear under the same heading on when can you come back?
After vacation.
No, after within, after 15 days or 20
How
days,
many
maybe.
days are left?
In this month, maybe any date, my lord.
10th Jan, immediately after.
Yes.
The matter appear under the same heading. No, no motion. 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 Next.
16.
My lord, I am for the petition. I am praying for only one recommendation. My lord, Mr. Saptangshu Bosu appear in this matter. My lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 14 December.
My lord.
Go under the heading motion proceed. Under the heading motion.
17.
My lord, in this matter, my lord, I am for the petitioner. Lord, what happened in this case, my lord? For non-disbursement of the
No, but patient on that motion.
okay, Mr. Koto. My lord, for non-disbursement of the redetermined award, my lord, I moved the writ application, my lord.
For?
Yeah. Non-disbursement
Of the award.
of the award. My lord, I have filed a writ application. This writ application was disposed of by your lordships. Your lordships kindly see page 28 of my application. My lord, relevant page is equal to my lord 29, my lord.
Yes.
My lord, from the first my lord, I am reading, disposed of directing the fifth respondent to place fund of rupees 5,36,999 before the fourth respondents within 2 months from the date of communication of this order. Such funds be disbursed in favor of the petitioner by the fourth respondents within a fortnight thereafter.
my lord, so far as the, my lord, first part of this order is, my lord, complied with. Now, my lord, kindly see second part. The petitioner are also at liberty to place their grievances with regard to quantum of compensation before the appropriate authority. In the event such application is made before the authority, the same shall be disposed of within a period of 3 months from the date of receipt of application by concerned authority after giving reasonable opportunity of hearing to the petitioners in accordance with law. My lord, as per your lordship's permission, my lord, I filed, my lord, application before the authority. My lord, annexing, my lord, approximate, my lord, amount which are I am entitled to get, my lord, a calculation sheet, my lord. This is, my lord, calculation sheet, my lord. If your lordships kindly see, this is, my lord, page 31, page 23. Yes, my lord. Page 23, P1, my lord. This is, my lord, according to me, my lord, this is my entitlement. My lord, thereafter, my lord, they did not dispose of my application, my lord. I filed a contempt application. In course of hearing of the contempt application, they, my lord, supplied the calculation sheet, my lord, in compliance with your lordship's order, my lord. If your lordship kindly, my lord, page 41. Achha. Yes, my lord, page 41, my lord, your lordships. My lord, has your lordship got it?
Yes.
My lord, it appears from the affidavit of compliance that the order under contempt has been complied with, that the applicant petitioners are aggrieved by the calculation made by the authority is a separate issue altogether and shall give rise to a fresh cause of action. Therefore, my lord, they next page, my lord, 42. 42, my lord, this is their, my lord, calculation sheet, my lord. They, my lord, supplied to us, my lord, in course of hearing of the contempt application. My lord, they, my lord, calculated, my lord, 5,33,6,999. And my lord gave out that this is the final, no other award can be given. My lord, if your lordship can. Jana. My lord,
And what was your demand, your figure?
yes, my lord,
What is the amount that you demanded?
P1, my lord. This is my calculation, my lord, calculation. Page 24. Page 20. 24. 27 lakhs, 15,738.
Lakhs and all, and they are saying 5 lakhs.
5 lakhs. Even your lordships kindly, my lord, with, my lord, your lordships kindly see page P3, my lord. Page, my lord, 31. Before that, my lord, page 34. 34, my lord, relevant page, my lord. In, has your lordship got it? 34, page 34.
Yes.
My lord, in 2012, my lord, the authority concerned calculated the determined award, my lord. It is amount to, my lord, 20 lakhs 76,007
565.
no, এখানে যেটা আছে ও আচ্ছা আচ্ছা মিলো 22 lakhs 6,65,616
5 official signature.
Milord endorsed by 5 officials, Milord. Your lordships kindly see, Milord. Milord, ignoring these, Milord, documents which they made themselves, Milord. They, Milord, only paid, Milord, rupees 5,36,000. Now your lordships kindly see the 32. 32. না রে ওদের ক্যালকুলেশন
ওদের ক্যালকুলেশন
32
না যেটা 5,40,000 টাকা
হ্যাঁ না ওটা নয় 5,40,000
5,40,000 লাস্টে
Melody, your lordships kindly see page 42 P7.
Okay. P7.
P6, Milord.
Yes.
Milord, serial number 7, Milord. Interest at the rate of 15% on 37,500 102 from,
3,75,000.
yes, my lord, I am from 10th of September to 19th of December 1993, my lord. এটা 42 পাতা। My lord, according to law, my lord, from the date of possession, first year 9% interest and thereafter 15% till the disposal of the realization of the money, my lord. And apart from these, my lord, solitium and other also there is other, my lord. My lord, they have given only 2 years, my lord, 15% interest. And my lord, they calculated, my lord, 5,36,919, my lord. Whereas it is their own calculation that I am entitled to get 22 lakhs, my lord. In year 2012, my lord. Now, my lord, my respectful submission before your lordships is this, my lord. Your lordship kindly, my lord, direct the respondent authority to recalculate my redetermined amount in the light of the annexure P3 and P6. This is my submission. Within a time-bound process, my lord.
P3 and P6. P6 is the reduced amount.
Their calculation.
Because that will not help you.
Yes, my lord.
P3 needs to be considered, not P6.
P3 will be considered. P3 to the document.
So they,
That will not be considered according to the provision of section 28A. The lordship will see the requisition land acquisition act 1894.
yes.
28A, my lord. 28A. May I be permitted to read, my lord?
28A, redetermination.
Yes, madam. Where in an award, under this part, the court allows to the applicant any amount of compensation in excess of the amount awarded by the collector under section 7. The person interested in all other land covered by the same notification under section 4. They are in the same notification under section 4. They are coming and to find that is the provision of section 28. Subsection 1 and was also agreed by the award of the collector may, notwithstanding that they had not made an application to the collector under section 8. They are not filed any application before the collector under section 18. By written application to the collector within 3 months from the date of the award of the court, well, according to the court, that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation forwarded by the court.
Section 28 has been
Within 3
filed.
months from the date of the court's order.
But here is there any court order?
Yes, according to the provision, well, section 28 court's order. If they are not filing any application before the authority, my lord, within the same delay case, my lord, within that period, and they must, and 28A, there is any order, and if they want to take that facility, my lord, without filing any section 18 of that provision, my lord, within 3 months, they can file this application according to the provision. My lord, your lordships kindly see back. Hey, আমি বলছি এবার মাইলি সি সরি স্যার তোমার তো বলার অনেক সময় আছে আমার রিপ্লাই দিয়া ঠিক আছে
This how will this provision be applicable, Mr. Dev?
that is 28.
28A says, when in an award, the court allows any amount of compensation in excess. The court in the order has not allowed any compensation in excess. The court has only granted the petitioner liberty to file an application.
Yes, my lord, that is the second part. That is the agreed by the award of the collector may, notwithstanding that they had not made an application to the collector under section 18.
It is only when the court enhances the amount.
Court is not, my lord. He filed an application after that, my lord. He filed an application before the authority, and authority, my lord, will consider.
This provision is applicable when the court enhances the amount.
Then, my lord, how they filed this application?
With liberty of the court. The court has not,
Liberty of the court.
court has not enhanced the amount.
Court will not enhance the amount, my lord.
This is applicable to the
According to
court
the
enhances the
provision,
amount.
according to the provision of the act, my lord, that is 4(1), if anybody is not taking that chance of getting section 18, my lord, they can file application under section 28. And they filed that application and court's order was there to file within 3 months, you will file an application and that will be considered by the authority.
However, this application has been filed following the judgment of the Land Acquisition Tribunal.
My lord, this application under section 28A was filed within 90 days following the judgment of my lord, Land Acquisition Tribunal, Howrah, my lord, which was disposed of, my lord.
By your lordship, application for
My lord,
18 of
my lord, Land Acquisition Act, the judgment was passed in case number 2018 of 1997, my lord. And following this judgment, my lord, I filed section 28A.
before the collector.
Collector, my lord. The collector, my lord, did not, my lord.
Seeking a duet song. Please,
Yes, ma'am.
one of you submit, please.
Yes.
You are repeating whatever your senior is saying, sir. Please allow him to submit.
My lord, I can't follow.
You are submitting together the same thing.
My lord, I am submitting here, my lord, that according to the judgment passed by the Land Acquisition Tribunal, my lord, I filed application under section 28A.
He is not the party.
My lord, no, my lord. There is same notification, common notification.
Party of that process, my lord.
Are you making the submission or is your junior friend making the submission? I would like to know this first.
My lord, following the judgment of my lord, Land Acquisition Tribunal, I filed application under section 28A before the collector, my lord. This is the law, my lord.
Yes.
My lord, my land is within the my lord, same my lord Mauja, that of my lord who preferred appeal before the Land Acquisition Tribunal, my lord. My lord, in the earlier read, my lord, I have paragraph, my lord, kindly see page 4, paragraph 6 and 7 onwards, my lord. I have stated, my lord. Your lordship kindly see.
No, you have the authority to, you are entitled to file an application. Even if you are not a party to the section
Yes,
18
ma'am.
application.
Yes.
That's the law.
Yes, my lord.
The section says.
Section 6, my lord.
Why does the states, why do you say that he is not entitled to the enhancement?
I am coming. Only for I am starting 28A. That is first part. That is filed an application before the authority. Provided that in computing the period of 3 months within which an application I may not want to do. 2 my lord. 28A2.
Yes.
The collector shall, on receipt of an application under subsection 1, conduct an inquiry after giving notice to all the persons interested and giving them a reasonable opportunity of being heard and make an award, a determination of the amount of compensation payable to the applicant. Second part, make an award. Now the third part, my lord, that is very important. Any person who has not accepted the award under subsection 2 may, by written application to the collector, require that the matter be referred by the collector for the determination of the court and the provision of section 18 to 28 so far as they may be applied to such reference as they apply to a reference under section 17. If they are not taking the money, then my lord, he can file an application under section 18 for reference. They are taking the money, they have nothing. So my lord, they have not any right to file. So my lord, they have not any right to get interest up to the date of the payment. He must file an application under section, my lord, according to the provision of 28A3. Yes, my lord. That application was not made before the collector. They send the matter to the reference before the tribunal court. That is the provision of law. For that is, my lord, he is saying that I must get the interest from the date of the award and up to the date of the giving them. That is bar
for a total recalculation.
Yes, my lord. That is bar of 28A3, my lord. Fresh reference, my lord, there is a given a chance for fresh reference. That is the provision of law, my lord.
Yes.
That,
My lord, law is clear, my lord, that if anybody fails to take the opportunity of section 18 or section 8, he can file application under section 28A for redetermination of the award.
The application.
I have made that application, and according, Milord, in that application, they, Milord, redetermined amount was fixed 5,36,000 and odd.
If
This
you're
is-
not happy with that,
Yes,
you-
Milord.
28A3 applies.
Yes.
Have you seen 28A3?
yes. Milord, Milord, as the Milord calculation is wrong according to law, Milord, tribunal order, Milord, in Milord,
Yes, I understand. It
Yes.
is wrong, so you have not accepted it. Yes, you've come up before the writ court.
read code.
Instead of that, you should have complied with 28A3. Please see the provision. Have you seen this provision?
Hmm.
I'll grant you liberty to comply with 28A3.
A3.
Please see the provision 28 capital A3.
Yes, Milord. Milord, my submission, Milord, as I did not comply with the section 18 or section 8 of the Act, Milord, I filed application under section 28A and
Under 28(1).
22.
28A1 entitles you to file an application even without going in for a reference.
Yes, Milord.
So you have done that, you
Yes,
are
ma'am.
aggrieved by the recalculation.
Hmm.
So then 28A3 comes in. The third clause.
Milord, tribunal has, Milord, passed the order, Milord, Milord.
That is earlier, that is section 18,
Yes, 8.
where you were not a party.
No.
So in terms of that order, you filed an application, 28A1.
Yeah.
You are not happy with the recalculation. So
Recalculate.
under 28A3, you can file an application before the collector for referring the same to the relevant court. Please come, 28A3 is very clear.
Milord, according to judgment of the land tribunal, Milord, Milord, it was Milord decided that Milord 30%, 15% interest will be given after 1 year, 9% up to 1 year.
That is the law.
This is the law, Milord. Milord, they have not done it, Milord.
So you have a recourse to law, sir. Please go through the provision before you submit.
Yes,
This is the
Milord.
exact provision of law that you have with you.
Was has not accepted. Not have accepted. Why have accepted?
Milord, I have accepted that amount, Milord. But, Milord, my acceptance, Milord, my submission here is that, Milord, the calculation which was made by the authority is wrong.
That 5 lakhs and odd you have accepted.
Yes,
Yes, Milord.
I have accepted.
Accepted, Milord. Your lordship's first part of the order, Milord.
Complied with.
Yes, yes, Milord.
5,36,000.
5,36,000 and odd, Milord, I have accepted that amount
And liberty was granted to file a fresh application.
Fresh application.
For quantum of compensation.
for quantum of compensation. Milord, I have done that. And reply to that, Milord, they have again, Milord, send the calculation sheet, Milord, 5,36,900 and odd.
The same thing.
Same thing.
Their own calculation P3.
But their own calculation says, Milord, it will be 22 lakhs.
Yes, but you have a specific provision under the law.
Milord, I have accepted the,
Have you complied with 28A3?
yes, Milord, according to your lordship's permission, Milord, I filed application before the collector. And in that application, they have done it.
That application was to be referred to the court for determination of the court. The collector could not have dealt with it.
The collector, Milord, decided that application.
That application should have been decided by the court and not the collector. Please come to 3.
Tribunal order
Upon liberty granted to you, you file an application according to your submission. You file an application under 28A3. Liberty was granted after receiving the amount. So that application should have been forwarded to the court for determination. Yesterday, the collector could not have decided this.
Collector, my lord, he filed the application according to the provision of 23, my lord. And because, my lord, he received the money as per order of the honorable court.
Yes.
Only for that reason, my lord,
Yes.
that previous order is, my lord, there is something added by learned friend who is that, my lord.
After the previous order, he filed an application.
Yes, my lord.
So the
But
collector
that
should have
application
sent
is
it
not
to.
considered as because, my lord, he filed an application under section 20. To refer the matter to the tribunal. Then, my lord, automatically that was done by.
Milord, they have not,
Done. The collector has decided.
Collector did not decide.
Where is the
Collector sent
Milord,
the matter to
collector,
the- according to the section, এই দাও আমাকে একটু বইটা। বইটা দাও আমাকে, বইটা
Has
দাও।
the collector said, where is the impugned order?
Yes, my lord, that is the, my lord,
Your application has been disposed of by an order. Where is that order?
yes, Milord.
Relevant হচ্ছে page 38 and 39. 38 করো।
my lord, there is a provision by written application to the collector,
Finally,
require that the matter be referred by the collector for the determination of the court.
Milord, your
Send
lord,
the matter to the, as a reference.
Have you made such an application to the collector?
yes, Milord.
Please show, where is your application?
Milord, your lordship kindly see page 18, 38, Milord,
Page 38.
38 and 39.
Collector pass the order.
Collector passed the order. আমাকে তো জজ সাহেব জিজ্ঞাসা করছেন।
তোমাকে না ওকে বলছি। ও পড়ে আসেনি নাকি তুমি বারবার?
38 is not your application. Where is your
This
application?
is the order, Milord.
I'm asking for the application. Did you request the
Application has not annexed here with Milord.
request the collector to refer the matter to the court? That is 28 A3.
Milord, as per your lordship's Milord direction, Milord, I filed application regarding the Milord error committed in Milord in calculating my reward. That application was disposed of by the collector, Milord, page 38 and 39.
The collector actually has no authority to dispose of the application. The court has to do it.
Collector ভুল করেছে।
This is the omission on the part of the collector, Milord.
Absolutely, the court has to do it.
Milord, then Milord, this order must be set as advice.
28(3), my lord, and collector will refer the matter to the.
Collector cannot take a decision in this matter.
Collector has
You're
not.
agreed. The collector decided an amount, you were agreed with that amount. How can the collector decide again?
There is a specific by the collector for the determination of the court. Specific language is there.
Court means, Milord, therefore, Milord, your lordship kindly refer the matter before the tribunal, Milord. Land acquisition tribunal.
That is the special court.
Milord, the original order passed by the land acquisition tribunal, Milord.
It has to be decided by the court.
Yes.
The court is the tribunal.
As Milord, they have not preferred any appeal. It's at in finality, Milord, finality stage, Milord. Appeal court's order should
But
be,
where
Milord,
is
prevail.
your application? That is required.
Milord, application, I have, Milord.
Contempt এর application করে।
For the collector,
6/9/2022 এই তো।
the 28(3) application.
Yes.
As per lordship
As per lordship's direction, Milord, I filed this application. Kindly see this. Report the.
it was about in the contempt application.
It was annexed in the contempt application.
Why not 2022 application?
This was filed on 6th of September 2022.
That was disposed of on 30th or 11.
Difficulty is the provision was not pointed out before the court in the earlier order.
Yes, ma'am. I have.
There is some difficulty with the audience.
Previous order was not. My lord,
As per your lordship's order, Milord, I filed this application.
Understand. Because the previous order, the collector was directed.
Yes,
So the collector disposed it.
for that reason, in this, my lord, your lordship clarified that the previous order and
Yes.
order and direct him to file an application under section 28(3) before the collector, and collector will send the matter to the court.
Will you file a comprehensive application before the collector?
Yes, yes.
According to the 28(a).
Yes.
সেটা কি রেফার করবে ট্রাইব্যুনাল?
My lord, collector will refer the matter before the tribunal.
Terms of the provisions. Collector cannot decide.
ডিরেকশন দেবে ট্রাইব্যুনাল।
My lord, your lordship kindly, my lord, direct the tribunal to dispose of the matter.
আমি বলছি my lord,
I'll be just
Or counsels for the parties.
অন করে দিতে বলে যে কবে রেফার করবে ম্যাটার।
Being aggrieved by the
Collector.
quantum of compensation
অর্ডার চলছে
allowed
Tribunal.
their favor.
ট্রাইব্যুনাল যেটা হাওড়া 1299 হয়েছে
সেটা কোথাও
আমরা করেছি 1897
By the state respondents, the petitioners filed a writ petition being WPA 16702 of 2021 for enhancement of the amount. Stop. By an order passed on December 3, 2021, this court disposed of the writ petition with a direction upon the
The tribunal passed the order on 12th of May 1999.
respondents with a direction for disbursement of the compensation in favor of the petitioners within a fortnight. Stop. By the said order, the petitioners were also granted liberty to place their grievance with regard to quantum of compensation before the appropriate authority, and in the event such application was filed, the authority was directed to dispose of the same within 3 months from the date of receipt thereof. Stop. The application submitted by the petitioner in terms of the order of the court was considered and disposed of by the Special Land Acquisition Officer within bracket G, bracket closed, Howrah, by an order passed on 13th or 3rd
3rd November 2022
3rd November 2022. Rejecting the request of the petitioners. Stop. The said order is assailed in the writ petition. Paragraph. To the equity proceedings. Section 28, capital A, within bracket 3 of the Land Acquisition Act 1894 envisages that any person who has not accepted the award under subsection within bracket 2 may, by written application to the collector, require that the matter be referred by the collector for the determination of the court, and the provisions of sections 18 to 28 shall, so far as may be, apply to such reference as they apply to a reference under section 18. In the case in hand, such application was filed before the collector by the petitioners and disposed of by the authority in terms of the earlier order of this court. Stop. The application ought to have been referred by the collector for determination of the court in terms of section 28 capital A within bracket 3 of the Act of 1894. Paragraph in view of the above, comma, the order impugned dated 3rd November 2022 is set aside. Paragraph, the writ petition is disposed of with liberty to the petitioners to file a fresh application under section 28 capital A within bracket 3 of the Act of 1894 before the collector is the respondent number.
Milord, may I submit one thing, Milord?
Yes.
Milord, in subsection 3, Milord speaks, Milord, that any person who has not accepted, but I accepted.
You have accepted it by order of the court, not on your own.
No, Milord. No, Milord. There is wrong something here, Milord. Milord, first part of your order, they have complied with. So far as the second part is concerned, they have not complied with. That is, they have made calculation wrongly. Against that order, Milord, I have come before your lordship here, Milord.
That calculation could not have been done by the authority. They have done a wrong calculation. It should have been decided by the court.
But I accepted the award money, Milord, in first stage.
You did not accept on your own. You accepted by order of the court.
No, Milord.
Please come to the earlier order. Please come to the earlier order. The court directed the authority to do the amount. Please come to the first part.
Yes.
It was the court's direction.
Yes.
You did not accept
Yes,
it
Milord,
on your own.
Milord, pardon me, Milord. I have not.
If you would have accepted it on your own, this would not be applicable. But that is not the case here.
Yes, yes.
It was only on direction of the court in the writ petition that you accepted them. Yes.
Yes,
So it is applicable.
Milord, I file application before the collector again.
Yes. He'll refer it. I'll record that. Collector is the 3. Fresh application. Fresh application.
Which are not. 3.
Before the land acquisition collector within bracket general, bracket closed, comma, Howrah, comma, being the third respondent hearing within 2 weeks.
Yes.
Within 2 weeks from date. Within 2 weeks from date.
No,
District magistrate.
land acquisition collector.
No, district magistrate for the district magistrate and collector.
The third respondent is directed to refer the application for determination of the court in terms of section 28 capital A within bracket 3 of the Act. Within 1 week of receipt thereof. So they within 1 week.
2 weeks. Because
Within 2 weeks from receipt thereof.
According to the provision of section 18, 28A, there is section 18.
So that is included in 28A3.
Yes, my lord, only for that reason.
Yes, so I have recorded 28A3 means it is included.
Yes, madam.
It should be in terms of section 18. That is recorded in this, it's there in the provision itself. Stop. The learned court is requested to dispose of the matter.
Land acquisition tribunal mentioned.
No disclosure.
The learned court.
Oh, after taking evidence, another thing, my lord. That
It will take time, yes.
take
As
time, my lord.
expeditiously also.
Yes, my lord, there is provision of
Dispose of the matter as expeditiously as the business of the court would permit. Comma in accordance with law.
No, landlords are not getting money, Milord, your lordship kindly direct land acquisition tribunal. You know, in 1991, Milord, land was Milord.
Recorded the provisions of the Act in total, whatever is in the Act. Yes, let the collector take steps. file the application, it will be sent within 2 weeks.
Within 2 weeks.
Yes.
My lord, they will refer the matter before the tribunal within 2 weeks, and the matter will be decided. my lord.
Tribunal is a court as expeditiously as possible.
My lord, preferably, my lord, within.
Cannot give such.
My lord, has there any role in the tribunal? Petitioners has any role, my lord, in the tribunal?
Adduce evidence. You have to adduce evidence before the tribunal.
Liberty to, my lord, give evidence, my lord, before the tribunal, my lord.
That is the law. Liberty is not necessary. That's the law. Disposed of. The moment it is referred to the tribunal will issue notice. In terms of section 18. I have referred court, I have stated, yes. So evidence is necessary. And it will be in terms of section 18.
My lord, original order was passed by the tribunal, my lord.
Maybe. 28A3 is court. Please see the provisions, it's very clear. Next matter.
18.
My lord, in this matter, my lord, I am for the.
18.
18, my lord, I am for the municipal authority, my lord.
Lord, I'm for the- Lord, this is the matter I'm challenging here.
For the state matter, I'm praying some more time to file my report in the form of affidavit.
My lord,
There was a
the last
direction.
submission, when the matter was called out on 20th of September, I categorically stated that all the petitioners before our lordships are all the senior citizen above 70 years. And their petitions are already, 4 petitions are already died. They are at a very bad state. Now, 20th of September, lordship, while continuing the interim order, directed them to file a report in the form of affidavit. But now, today, we are on the 1st of December. But kindly consider, if that be the fashion.
1 week time.
12th December.
Lordship.
12th December, positively.
Yes.
I'm grateful.
Learned Counsel for the state respondent seeks extension of time.
Notice.
Submit the report in the form of affidavit.
Notice for-
Matter. Paragraph, let the matter appear under the same heading on 12th December 2023.
Nineteen.
My lord, I accepted on behalf of the petition. My lord, this is an application under section 3G5 of the National Highways Act, my lord. My lord, this matter is relating to inadequate amount.
Is it there for the state? What about the national highways?
My lord, on lost occasion, they have appeared, my lord. They have,
Last occasion,
they, I mean,
no one appeared.
prior to that, my lord, they have,
Your affidavit of
affidavit of
service.
services is on the record, my lord. They have appeared once, my lord.
I do not see any record.
Oh, my lord.
So they appeared all throughout. I'm for the state. Yes, yes. So they appeared for the state all throughout. Where is your service on national highways?
My lord, I suppose it is submitted on last, it is not there.
There is no affidavit of service.
Oh, my lord, I don't. In that case,
There is a recording since service is not complete, the matter was adjourned.
oh, I'm sorry, my lord.
And the Union of India, you preserve both.
I will come out.
Since service upon the respondents is not complete, let the matter stand over till after vacation.
No, my lord, any day before vacation, my lord. It's just a matter of few minutes, my lord.
15th December.
Extremely grateful, your lordship.
Please serve in the meantime.
I will, my lord. I will definitely, my lord. I will definitely.
The Union of India and the National Highways.
Yes, my lord.
20.
Much will
My lord,
No, no.
I'm for the petitioner.
my lord, behalf of the added respondent number 6 in this matter, I am praying for a short passover. Behalf of
Passover is not possible in this.
My lord, my affidavit of service.
my lord, kindly at least not today, my
Well,
lord.
this is the matter
One day
where, my lord, the land has been utilized without any acquisition. And, my lord, I made the government respondents as parties. Your lordship was pleased to direct me to add panchayat as parties. My lord, I have made all the entire hierarchy of the panchayat as parties, my lord.
You are appearing for the panchayat.
Yes, my lord, I am praying only for one day accommodation, my lord. Mr. Oshimati is appearing in this matter for the panchayat.
14 shotaks of land has been acquired, has been utilized without any acquisition. I have given the title, and Lordship will kindly see page 69, the photograph. And
State, Mr. De. So the state is the answering respondent.
Yes, ma'am.
Page?
page 69 is the photograph, my lord. Page 70 is the map, which shows that how the land has been utilized.
What is your prayer?
And my prayer is that, my lord, compensation or something has to be done, my lord. There is no acquisition at all. My land has been utilized.
My lord, that is the Gram Panchayat, Pradhan Mantri Gram Sadak.
That's why.
Yes, I have made partners.
My lord, Panchayat must appear.
She is appearing for the panchayat.
My lord, I have no instruction for that. That's why I am praying for not today only for this matter. Only not.
Not today, as she says.
My lord, give him some time, my lord. Otherwise, my lord, he must come. He is the answer.
I
But
think she has instructions. She's only asking for
some positive instruction.
not today. Let it be not today.
My lord,
Some instruction must come, my lord.
only two.
Lordship, kindly direct them to take some instruction and come back to your lordship. Lord.
My lord, I have some instruction to make this matter not today only.
You have your instructions with you. She has it.
Only not today.
Not today.
Only not. No.
Next. It will appear on Tuesday, not
Tuesday. Yes,
Monday.
yes, that's what.
Still appear.
Yes, Tuesday.
I'm keeping the supplementary list matters separately.
Yes, yes. Deeply obliged. Deep. But affidavit of service being kept. Affidavit of service I have filed. Lord.
What is being passed?
As you know.
21.
Lordship, I am for the petitioner's hearing. And affidavit services be kept to the record. But the impugn order, Lordship, has been challenging the order passed by the principal secretary.
So Mr. Bandyopadhyay is appearing.
Impugn order,
Matter was referred to the Principal Secretary, Commerce and Industries Department for taking a decision on the representation.
Lordship.
That representation has been considered and rejected by the principal.
Otherwise, the petitioner would not have been here.
No.
Yes, no, the rule 51
is not applicable
is not
here.
applicable. It is with regard to district administration. But here the decision has been taken by the Principal Secretary, Industries, Commerce and
Department of Commerce and Department.
That decision is challenged.
Lordship, it cannot be decided without calling for affidavits. Because the state will.
Lordship, affidavit may be exchanged, but in the meantime, some protection be given to that effect. Lordship, in the event the sand block is put on auction, then the entire writ petition will be infractual.
Lordship, I am not.
My lord,
Force majeure clause.
this was granted in the year 2017, in the year month of May. It has already been expired in the year 2022.
Maybe.
But 21 policy is not applicable, number one.
And one-time extension has been given in terms
No.
of the government circular.
That is that
is why
3
that
months that is
Indicated in the
that has
order
not been applied in this matter.
Yes, yes, it is applicable.
And the Principal Secretary has stated in the
already
impugn order.
In the meantime, come back on.
If it is not, Lordship, may I just,
Not allowed.
there are several plots or sand blocks which are put into auction, lease has been executed,
Lordship.
unless it has not, Lordship kindly remarked it, that if it is not,
With the instructions in that case, with the documents.
Lordship.
Has been executed. Because our conditional order cannot be.
Yes, yes, Lordship, kindly
Not today.
direction, instruction নেব যে auction হয়েছে কিনা, যদি না হয়
ঠিক
তাহলে
আছে।
It may have
Or
been
after
done already.
coming
Yes,
into
Lordship.
cancer mining policy, it is not in our hand, it is with the
Yes,
Mr.
the
Saab.
development.
yes, yes.
Not today.
Not today.
Lordship,
Only
kindly,
instruction.
Your Lordship, kindly pass an order. I will seek instruction that the court has asked to whether this
Lordship.
particular sand block has been put into auction or not. Lordship, kindly pass it on, keep the matter on Tuesday.
Tuesday or next week.
It will automatically appear on Tuesday if it is made not today.
Lordship.
Because Monday is a matter list.
Yes, yes.
So
Well, let's-
monthly matters are not being taken together with the.
Then Lordship, kindly grant me some more time because
Lordship, actually, my liner friends is seeking a order so that they can
apart
show
from
the
that,
department.
yes, that this is the order, you kindly furnish me
particulars whether this particular sunblock has been put into auction or not.
Yeah, very well. Which is the order challenged page?
Lordship, page 108, started 108.
The order
Lordship, order dated 10th January 2023,
passed by the
Principal Secretary.
Principal Secretary, comma, Department of Industry, comma, Commerce and Enterprises on 10th January 2023 is assailed in the writ petition.
Vikram.
Learned counsel for the petitioner seeks a direction upon the authority not to create any third-party
Correct.
interest in respect of the plot in question. Stop. It cannot be ascertained whether the plot has already been auctioned and lease executed in favor of any third person. Stop. Learned counsel for the your respondent number
Five.
fifth respondent
Five.
seeks to take instructions in this regard.
Five.
Paragraph that the matter appear under the same heading on 6th December.
Lordship, six.
Only this instruction.
Lordship.
I'll call for application.
Lordship. Grateful.
Sixth.
22.
22, my lord, I am for the petitioner. I am for the petitioner.
Yes.
My lord, the grievance of the petitioner is, my lord, encroachment over a government land, my lord. This is, my lord, second round of litigation, my lord. Previously, my lord, your lordship, by an order dated 11th November 2022, was
Have you
placed to, my
served
lord,
private respondents? Where is your
Yes, my lord,
service?
yes. I have served.
There are several private respondents.
Yes,
right
my
now.
lord, yes. I have served, my lord, and it has been delivered upon all the respondents.
The diary holder. Nice. Where are the other track reports? Yes.
Your lordship was by an earlier order, my lord, dated 11th November 2022. Your lordship was pleased to pass an order directing the respondent PWD authority to initiate a proceeding under Section 10 of the West Bengal Highways Act, my lord. Pursuant to such order, my lord, they caused an inspection, my lord, and initiated a proceeding under Section 10 of the West Bengal Highways Act. My lord, kindly come to page number 15, my lord. 15A is the, my lord, type copy of that order, my lord. In point number 2, my lord, the PWD authority has conclusively came to a finding that the petitioner as well as the private respondent of the previous writ petition, and there are several other respondents also who have encroached over that plot of land. Now, now on the basis of such finding, my lord, the PWD authority, my lord, passed an order directing the petitioner and the private respondent of the other of the previous writ petition to remove the unauthorized construction, leaving, my lord, the others who are also similarly circumstanced with the petitioner, who are also encroaching the government land. Thereafter, my lord, I caused representation upon the state respondents, requesting them to remove the other respondents also who are encroaching over the government land. But, my lord, they are sitting tight over the issue, and it is, my lord.
So these respondents are not included in the other
No.
proceeding?
In the previous proceeding, they have not been included, my lord. But in the present writ petition, I have added them as private respondent, and what I am humbly praying before your lordship, kindly pass a direction upon those upon the government authority to pass a direction to remove the unauthorized construction of those respondents also.
Yes. Against these persons also? The private respondents here?
And some of the private respondents already including the track of the and to the last. There is a man. Some of her husband, some of the private.
What is this acquired by means? Acquired by Muntikava, acquired by?
It should be input, must be. Only it is a support, it must.
What about the others?
Inquiry must can be done. It says that their private respondents are not satisfied with the RTL. As per the order of the order.
So a fresh proceeding has to be initiated.
Yeah, it can be done.
But, my lord,
It has been done under section 10. It is the
But these respondents are not included there.
no, that respondent is not there in the RTL.
Yes, so again, you have to make a fresh survey and find out. Is there any observation that these respondents have also encroached?
Yes, my lord. In the order, my lord, point number 2, may I read, my lord?
Their names are not there.
Names are not reflected in this. Yes, my lord. But there is a categorical finding to that effect that the respondent Manju Bewa and others have encroached 10 feet and 10 feet into 44 feet. That equals to 440 square feet. Manju Bewa and others.
Manju Beva is a respondent in this matter? No.
It is already shown.
Manju Beva was also a private respondent in the previous writ petition, but the others.
In this writ petition also you have included Manju?
Yes, Manju Beva, I have included her also. But, my lord, the other, other respondents, that is, my lord, private respondent number 9 to 17. They are, my lord, also encroaching upon that government land.
Where is that record?
My lord, that has to be found out from that by way of a fresh proceeding, my lord. They have already categorically, they have, my lord, inspected the spot and have come to such finding, but the names are not reflected in this order, my lord. In that.
Representation regarding this name because we have to
File a fresh
Yes, my lord, kindly direct.
Yes.
So, my lord. Yes, my lord.
Lifted the service. Paragraph, none appears for the private respondents despite service. Paragraph, it is submitted on behalf of the petitioners that pursuant to an earlier order of this court passed on November 11, 2022 in WPA 7217 of 2022, proceeding under section 10 of the West Bengal Highways Act 1964 was initiated
Case 16 against 4.
against the petitioners, comma, the private respondents of the earlier petition, as well as the 8th respondent herein, who was also impleaded as one of the private respondents earlier. Stop. The petitioners submit that private respondent numbers 9 to 17 have also raised unauthorized construction by encroaching upon PWD road.
Yes.
PWD road. Stop. The petitioners seek to submit a comprehensive representation before the concerned authority in this regard and pray for a direction upon the authority to dispose of the to consider the representation at the earliest and initiate proceedings under section 10 of the Act of 1964. Paragraph. Learned counsel for the state respondents submits that the 6th respondent should 6th respondent that the 6th respondent be directed to consider the representation in accordance with law. Paragraph in view of the above. Yes.
Already indicated the competence.
That is not the prayer in this. That's a different issue altogether. Isn't it? Otherwise, he'll come up with a contempt application. This is a different issue. These are other respondents. In view of the above, the petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the 6th respondent within 2 weeks.
Yes.
Within 2 weeks from date. Stop. The 6th respondent is directed to consider and dispose of the representation within 3 months, because evidence is required, within 3 months from the date of communication of this order. Upon, let it be 2 months, because the demarcation is over in the earlier matter. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Act of paragraph rule, since demarcation of the plot in question has already been made pursuant to the earlier order of this court, in the event it is found that the private respondents have encroached upon the said land, proceedings, the 6th respondent is directed to initiate proceedings under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within the time frame mentioned above. Disposed of. And a report submitted on behalf of the state respondents is taken on record. I'll take this on record.
23.
Yes.
My lord, I have made an application for long-term mining lease.
For?
My lord, what happens?
Long-term mining lease.
Long-term mining lease. My lord, what happens, my lord? Additional district magistrate has been rejected the application on the ground of 16B, which has been declared ultra-vires by this honorable court. My lord, I then and then made an application to reconsider my application on the basis of that since the rule has been declared ultra-vires, on the basis of that, the department has given me the answer that since we have preferred an appeal, until the appeal is disposed of, we can't accept your application. When the appeal has also been dismissed. Well, in the same matter, well, come to page first.
Who has preferred the appeal?
What?
Who has preferred the appeal?
State government. State had prepared an appeal at that time. Well, come to page, my lord, first. Page 22.
Yes.
Page 22. That additional district magistrate, that on the basis of option, they prescribe the 16B, this is amendment rules. 16B has declared out of has. My lord, come to my lord. Then page, my lord. 25, 26. The division bench has already declared, my lord, on the same matter. My lord, I made a representation then and then. তোমার এই না এই এটা আমি তুমি দিয়েছিলে on the same matter, your lordship passed an order.
This is the representation.
Yes, my representation is page.
Page 27.
Page 27. চন্ডিকা কেন তোমার যাবে আর কপি করে গেল চন্ডিকা তুমি যাবেন তার কেন তোমারই তুমি ছিলে আমার সবাই একই যাবে ওই তো একই I'm preferring the same order.
Counsels for the party. It is submitted on behalf of the petitioner that
কি বলছে এই তো মৃণালদা ছেলে মৃণালদা মৃণাল বিশ্বাস ওকে নিয়েছি ওকে থাক
an application filed by the petitioners for grant of long-term mining lease upon depositing requisite fees was turned down by the authority on the ground of amended Rule 16 capital B of the West Bengal Minor Minerals Rules, 2002. Stop. The said rule, R capital, was declared ultra vires by a coordinate bench of this court in a judgment passed on 4th July 2014 in WP 16526 within bracket W of 2013. Paragraph. The petitioner submitted a representation before the concerned authority requesting setting aside of the order of rejection on the basis of the said judgment and was informed that the state had carried the said order in appeal before an honorable division bench. Paragraph. Learned counsel submits that the appeal was dismissed for default. The appeal being MAT 2037 of 2014 was dismissed for default by an order passed by on 8th April 2022. Stop. Immediately thereafter, the petitioner submitted a further representation before the authority on
July 2023. 12th July.
12th July 2023. Seeking reconsideration of his application for grant of mining lease in terms of the order passed by the single bench of this court. Stop. The said representation is yet to be considered. Stop. The petitioners pray for a direction upon the authority, authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that who should consider? The fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of directly to fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 4 weeks. Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner.
6 weeks. The date of communication of the order.
And in the light of the observation made by this court in the order in the judgment passed on 4th July 2014 in WP 16526 within bracket W of 2013, in accordance with law. Paragraph, the decision taken by the authority will be communicated to the petitioners within a week thereof, disposed of to judge. You can take this back. Mention matters. Mention matter 498.
Lordship, in this matter, Landed Advocate Pushenjit Mukherjee is appearing, Lordship.
Yes.
There is a bereavement in his family, Lordship. Kindly fix it 498 and 499 both, Lordship, in Monday, Lordship.
Monday will not person come back after vacation.
Lordship, kindly after vacation, it will be difficult, Lordship.
On prayer of the petitioner, have you served? Mr. Day, you are appearing. On prayer of the petitioner, the matter is adjourned. Petitioner. Paragraph, let the matter appear under the same heading on 19th December.
19th December, Lordship. I am grateful, Lordship.
498 and 499, same order.
499.
Same order.
501.
500.
500, I am for the petition. But I am in dilemma to move this matter because Miss Monali Bisha is appearing for the private respondents. Few minutes back, she called me and she said due to expiry of some of her relative, he left the court. Or I am in urgency, but I can wait. Hello?
That is before a few weeks, you said.
No, few minutes.
A few minutes.
When I was entering into this courtroom, my lord, just she called me. So I had to convey to your lordship. Only not today, my lord.
Please for the private respondent.
Private respondent. Wait.
$101.
My lord, I am for the petitioner, my lord. My lord, the petitioner was selected as H1 bidder.
Yes, madam. Obviously, they should go to the circuit bench also. Matter either to the Dokhin.
Yes. It's a circuit bench matter. Why before this court?
It is circuit bench.
Balurghat is not included in circuit bench.
Oh.
It is not included in circuit bench.
My lord, the petitioner was selected as H1 bidder for e-auction in respect of sand and boulder mining, in respect of 12 acres of mining plot. After that, letter of intents were issued to the petitioner by the concerned ADM, and after that, it was found that no demarcation was made, and out of the 12 acres of plot, only 4 acres of plot was found to be appropriate for the mining. The petitioner made his representations and told them about their grievance, and the petitioner was called on for hearing for 2 times. But my lord, none of the order was served to the petitioner ever. And after that, when the petitioner went to the ADM's office in 2023, he was served with a order sheet which is purported to have been passed in 2018, back in 2018. And the order says that the complete bid amount which the petitioner has advanced, it will be forfeited and he will be completely restrained from participating in other e-auction processes, which is arbitrary and illegal, my lord. My lord, if they can show that they have served this order sheet back in 2018, then my lord, I do not have any case. But my lord, the petitioner was never served, my lord.
Let us hear the authority. Violation of natural justice.
It is for the first time that order was passed on 4th of January 2018.
Is it communicated?
See that Mr. Bogavandai assigned it was communicated as a petitioner. Although it was conducted in 2017, sat tight for at least 5 years.
No, my lord, he has made several representations. Nothing was considered, my lord.
What else? He cannot go and catch the feet of the authority. Representations have been made.
Approach the court earlier. So whether it was communicated,
That is the primary issue. Instructions.
Without instruction, I can't say.
Yes.
Without instruction, I am not.
Yes. The only instruction necessary is whether the order was communicated.
Whether it has been communicated or not.
It's heard. If it is communicated,
It appears it's a certified copy.
then 51 comes in. If he is not communicated, then it's a violation of natural justice.
Well, it was never communicated.
Come back with
Certified copy. Whether it is communicated or not, I have to take instruction.
There should be some document of communication.
এটা জানতে হবে যে ওকে অর্ডারটা কমিউনিকেট করতে হবে।
There should be some document of communication. You've challenged which order or order page?
Last order was it?
My lord, page number 68, my lord. Page number 68.
The order,
My lord, in the meantime, this order may be stayed and let them file.
yes,
This order may be stayed, my lord. My prayer, my lord. In the meantime, this order may be because
28th order stayed in 2023.
because
How? Let us see whether you were communicated.
Okay.
If you have been communicated, then appeal lies.
all right, my lord.
It's an appealable order. Otherwise,
All right.
some document to show that it was communicated in time. The order passed by the District Land and Land Reforms Officer, on 4th January 2018 is assailed in the writ petition. Stop. Learned counsel for the writ petitioner submits that the said order was not communicated to the petitioner at all, despite several representations submitted by the petitioner before the authority. Stop. When did you approach the authority? 2023.
My lord, lastly on 27/7/2023. 27 July 2020.
It was only on 27 July.
Lastly, it was communicated on
27 July 2023 that the petitioner was informed about the order impugned. Paragraph, learned counsel for the state respondents seeks to take instructions as to whether the order impugned was communicated to the petitioner at all, and if so, comma, the date of such communication. Paragraph, let the matter appear under the same heading on last week before the vacation. It's a short instruction.
I don't know whether I shall get it or not. I shall try. But sometimes
18th December,
18 December.
last week.
I'm trying.
Because it's otherwise a short matter. If it is communicated, it goes.
18 December. Not yet.
I'm for the petition, Lordship, led by Mr. Pan.
Yes.
This is affidavit of service, Lordship.
State,
Yes, Lordship, I have served notice, Lordship.
who is appearing for the state?
Uh,
No one.
Shantanu Basu is appearing, Lordship. I have served notice before mentioning, Lordship.
Where is he? He has been allotted. From the state panel.
Yes,
Yes, Lord.
And then who's appointed Mr.
Yes,
Dev?
Mr. Kindly appoint Mr. Dev, my lord.
The seek some other name.
No, my lord,
But-
Shantanu was engaged by the GP.
Yes, Lordship.
I was served, notice was served upon him at the time of mentioning, in spite of that, he is not appeared.
Lordship, this is the notice, Lordship. I
The panel. Shantanu Basu.
চন্ডিদা আপনি অ্যাপিয়ার করে যান হ্যাঁ আপনি অ্যাপিয়ার করে যান না
I may I request Mr. Dev.
Yes.
I do not even know whether he's.
Yes, Lordship.
No, I'll record his appearance. Mr. Dev. Our copy to send us.
Although the prayer seems to be very innocuous, but it's a foundation work. But there is some dispute with regard to the document annex at page 21.
Lordship,
Because same
may I
Let's hear the petition.
Because same notification, my lord, I have some instruction there, the quantum of land is different.
Is different.
Lordship, may I please,
Here-
Lordship?
Here, in respect to one plot, the gazette notification shows 10 decimal, which the petition is claiming. But the same notification, in my instruction, I find from the notification supplied to me, it is 15.
দে না আমাকে দে না
Get a copy.
দেখুন একটা কপি দেন
Lordship, kindly come to the page 21, Lordship. 21, Lordship.
Let's hear the petition. Yes.
Here, Lordship.
দে না সত্যি কি
One Lordship, Anil Kumar Ghosh, he is a predecessor in interest of the petitioner. In the year 57, Lordship, he purchased the land. And Lordship, I have annexed the deed of purchase. Lordship, kindly come to the page 14, Lordship.
1414.
1-4.
Yes.
First line, Lordship, Mr. Anil Kumar Ghosh names is appearing as a Grohita. And Lordship, then Lordship, kindly come to the page 17. Last two line. Plot number 2469. Area about 27 acre, Lordship.
Yes.
Then Lordship, kindly come to the next page 18. 2494. Plot number 2494. Page 18. 18.
2494.
Yes, Lordship. And area is 9 shatok.
Yes.
Yes, Lordship. Then Lordship, kindly come to the page. Subsequently, Lordship, the possession of the land was taken over in the year 80 by serving a notice under section 3(1). And notice was served in the name of the Anil Kumar Ghosh. Therefore, Lordship, subsequently the section 4 notification was published and 4(1) notification published, Lordship, and that I have annexed. That is page 20, annexure P3.
It's not very legible.
I have a typed copy, Lordship.
This is the 4(1)A notification.
Yes, Lordship.
দিদি
Yes.
Lordship, kindly come to the second page of typed copy, Lordship,
21
and 21 of my petition, Lordship. First, second, third, fourth, fifth. Lordship, kindly see the first line. Revisional survey plots in part. My plot is appearing under this column, Lordship. Lordship, kindly come to the first, fifth, 2469. Serial number 5, Lordship. First, second, third, fourth, fifth, Lordship. 2469.
In the first page.
page 21 next page second page of the
মানে
notification
Lordship, type copy টা দেখছেন।
হ্যাঁ টাইপ কপি সেকেন্ড পেজ
The second page,
সত্যি কপিটা
Where is 2469 in the second page?
in the type copy, Lordship.
In the typed copy?
Yes, Lordship,
And instruction
2469, first, second, just right hand side column, Lordship, first, second, third, fourth, fifth, number fifth, 2469.
2469, yes.
area is, acquired area is 0.10 acre, Lordship. And my area, total area is 0.27 acre, Lordship. And Lordship, the second number is appearing in serial number 16, Lordship, 2494.
Let me hear her what she says.
2494.
494, yes.
Area is only 0.4, Lordship. My total area
Out of 9.
out of 9. So Lordship, here Lordship, at present Lordship, subsequently the present petitioner became the owner of the land. And my prayer is this, Lordship, kindly direct the respondent to demarcate the acquired portion of the land. Till date, they didn't. Under the similar circumstances, Lordship,
Purchase the remaining portions in both the
not
plots.
purchase, Lordship. Lordship, kindly come to the page, paragraph 5, Lordship. I have explained. Paragraph 5, page 4. Paragraph 5, page 4.
Yes.
That Anil Kumar Ghosh died on 23rd January 2020, leaving behind the petitioner.
Oh, surviving legally.
Yes, Lordship.
Inherited the property.
Yes, Lordship. He is inherited property.
That's your case.
Yes, Lordship. Lordship, kindly come to the section 9C of Act 2.
Let him come back.
This notification, justice should annex this notification.
I have already annexed.
ঠিকই বলছে সত্যি
That's the page 21 notification.
21 notification.
1A notification, yes.
In respect of plot number 2469,
Yes.
it is at page 29, it is shown as 10 days. But my instruction is 15 days.
It is just above that. 2467 is 15 decimals.
টাইপিং
It is a
মিস্টেক তোদেরটা টাইপিং মিস্টেক
2467 is 15 decimals. Just above this plot.
So, my lord, this is
তোদেরটা টাইপ কপি
at page 28. Report
Yes.
is shown as 10 decimals.
সত্যজিৎকে আমার
The state
2469 is 10 decimals.
yes, yes.
Just above that is 2467. That is 15.
টাইপে গন্ডগোল করেছে
Confusion.
2467 is
No,
not.
no, and you are saying 15 decimals, maybe there is some confusion.
Yes, not a fine evidence.
This is your copy.
My instruction and the notification. The same notification.
your is type copy not the
Maybe
certified
that,
copy.
but
এর আগেরটা হচ্ছে 15 ডেসিমেল
appears to be the certified copy.
কেন্দ্রীয় সার্টিফাইড কপি টাইপ কপি অ্যাপ্লাই করেছে উদর পিন্ডি বুকের ঘাড়ে চাপিয়ে এসেছি আমি জায়গা বা চল তোকে দেখাচ্ছি
Not only this type copy, I have got written instruction, that is why.
রিপোর্টে ফাইল কর না তারপরে দেখছি
Can be
The
resolved.
typed copy must be, there is some.
Yes, yes, that is why I am not.
There can be a confusion because 15 after that 10.
Yes.
So maybe there is a typographical mistake.
Yes, there is possible.
That is, in all probability, it is a typographical mistake. Will you come back with the report, separate report?
You know, if the state produces
চুপ কর না
the notification. Yes, that will do.
That will suffice?
Yes, that will do. But more we can show.
Affidavit of service. Paragraph. The petitioner seeks a direction upon the respondents to demarcate the acquired area of plot numbers 2469 and 2494 acquired vide LA proceeding, vide LA case, vide case number LA hyphen Roman 2/105 of 1976/77. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of an affidavit in this matter. Paragraph, let the matter appear under the same heading on after vacation.
Can I seek that notification?
That's the basis.
বিশ্বাস করছেন অবস্থিত হয়েছে আমি আপত্তি করছি না
Next.
বিশ্বাস করছি না না ওটা লেখা থাকলে অফিসার
কাগজটাও দিয়ে দাও কাগজ
3.
দাঁড়াও। সার্ভিস আগেই বলো কোথায়
Yes.
এটা দিক ঠিক আছে সব সার্ভ তো হ্যাঁ এটা একটু নিন এভিডেন্স স্যার pilot eviction of unauthorized occupants act 1962 yes everybody and the subsequent development
Private respondents.
nobody subsequent development on the strength of this
First that
my lord
you are appearing for
state
What about the private respondents?
well it's delivery
Served
confirmed
all of them.
delivery confirmed
All of them.
all
Which 9 জন আছে
Dispatch to BDO. First is not confirmed. Where is the delivery?
first one
9 জন হ্যাঁ
Dispatch to BDO. These are not delivery.
my lord may I check my lord তুমি দেখো ডেলিভারি কনফার্ম তো বলছো কি করে জাজ সাহেব দেখছে দেখে একবার দেখান তো তুমি লাস্টে যেটা বের করেছো এটা কোথায়
The last 2 pages.
ডেলিভারি কনফার্ম
মানে ফার্স্ট অন ডেলিভারি delivered to Joydev Manna
Last 2 pages.
last কোথায় dispatch delivery নয় no these two are dispatched not delivered
I've just seen the last 2 pages.
my lord I'm sorry I am
প্রথম মানে
Complete.
service complete করতে বলো my lord I submit one thing after this writ petition the department has proceeded with giving notice to all the respondents inspection and survey has also been conducted therefore now this proceeding since been initiated by the department that has to be concluded that is my prayer
I understand, but this becomes a ground for appeal.
lordship
It will again come back and say,
lordship তুমি service করো complete
11th December, sufficient?
yes
That's why I'm giving you a short date because proceeding has been initiated.
my lord
11th December.
by this time অবশ্যই করো
Since service upon all the, please check.
my lord 2-3 are left my lord I will serve only to them
Find out the next track report, the subsequent track report.
very good
You have taken out till dispatch.
list
So the subsequent track reports may show service.
lordship
In any event, service has to be made.
তুমি দেখে নাও নাহলে আবার পাঠাও
না এটা হয়ে গেছে এটা
আজকে দেখে নাও নিয়ে আবার পাঠাও
Service for all the private respondents is not complete, comma. Let the matter stand over till 11th December.
11 December my lord হয়ে গেছে যেগুলো হয়ে গেছে সেগুলো দরকার নাই বাকিগুলো হয়েছে কিনা দেখো পরের মামলাটা ভালো করে আগে দেখো ভালো করে দিস ইজ মাই অ্যাপ্লিকেশন মানে লেট মি চেক ফার্স্ট ডেলিভারি কনফার্ম and item delivered there are only 2 respondents delivery confirm 2 তো respondent দেখেন আগে দুটো আছে কিনা
Only
serve মানে
one private respondent.
Javed Ali delivery confirm yes
Please file the affidavit. of
item
service.
delivered addressee এটা কি
Yes, what is the matter about?
this is also unauthorized occupancy act my lord 1962 very well let that be concluded within certain period of time
Instruction.
What initiative has been taken?
What is the state of inquiry?
দিয়েছো
State of inquiry? হ্যাঁ
কোথায় সেটা কোথায় সে কাগজটা দাও
Proceeding has been initiated.
Lords, kindly sit. This is the second part because at section 4, DM has to take a decision that has been done. Thereafter refer to the SDO. SDO inspected, inquired. Memo of SDO is there.
It's the 62 Act. Affidavit of service. None appears for the private respondent despite service. Paragraph, it is submitted on behalf of the petitioners. It is adjoining your plot
Yes, just in front of my.
that the private respondent has encroached upon government land by raising unauthorized construction therein. Government land adjoining their plots. Adjoining their plot. By raising unauthorized construction therein, comma, thereby
Collector কত number?
obstructing their ingress and ingress. The petitioners
কত?
submitted a representation in this regard before the concerned authority on no date.
District magistrate date কোথায়? Received by the subdivision on 4th September 23, page 15. Yes,
In this regard, which was on the
17 to the DM.
which was received by the authority on 22nd September 2023. Stop, the representation is yet to
No,
be
my lord, 4th
considered.
September. Act of seal one.
Oh, the date is 31st of August.
No, this is
Date
the
is 31st August.
date received on 4th September.
No, the application date is 31st
Date
August.
31st August.
On 31st August 2023, which is yet to be considered. Stop, the petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that pursuant to the representation submitted by the petitioners, comma, inquiry has been held by the authority and upon detection of unauthorized detection of illegal encroachment upon government land, comma, proceeding under the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, comma, 1962 has been initiated. That is your submission. Paragraph, in view of the above, comma, this court is inclined to hold that since proceeding under the Act of 1962 has been initiated, comma, the concerned authority being the SDO.
No, collector, the DM. Section 4.
The SDO had given an instruction to the PLRO to take an inspection. The PLRO has taken an inspection.
Yes.
That is
But
now
under the
The proceeding.
the
author-
procedure needs to be concluded.
authority is the district magistrate under section 4. The lordship kindly sees.
But the SDO is empowered.
SDO, if he is delegated, then he can do so. But the authority under the act is magistrate.
But there is a notification subsequent in following that,
Achha.
that the SDO has been delegated.
Very good. Let the SDO be direct.
The fourth respondent hearing, comma, be directed to take the proceeding to its logical conclusion within 2 months from the within 2 months from the
2
date of
months.
communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners and the private respondent, comma, in accordance with law.
Yeah.
Disposed of.
And it is, if it is found, my lord, illegal,
Found.
then it has to be removed.
It's already found, so the proceeding says removal.
Very good.
Upon detection, proceeding has been initiated. No, madam.
ওটা এমনি আছে
আছে বলতে বলুন না হলে করবে না
You have just said that the proceeding has been initiated.
Inquiry has taken procedure. The SDO has to conclude.
Only upon detection of an encroachment.
Yes.
Otherwise, it would have been done.
করবে না কেন
Next.
বলেছি
505.
I'm for the petitioner. In this matter, my lord, state has been served, the requiring body, my lord. We have served, it has come back, then we made some inquiry. It appears, my lord, that district telecom engineer, telecom district has been converted to, my lord, BSNL. So kindly give me leave, my lord, to correct the cost title so far as respondent number 3 is concerned. But regarding the matter, my lord, I'll make the changes. So far as state is concerned, in this matter, there is a long history. Initially, acquisition started under Act 1. My entire land. They abandoned it. Then second acquisition started under Act 2 by leaving a strip of land aside. So that strip of land becomes redundant because I cannot use that land. Act 2. They took possession under Act 2. My strip of land becomes useless. I challenged it, saying that no, you cannot do this because Land Acquisition Act also there's a provision that if you take a land and portion is left aside, then for that compensation is payable. This honorable court passed an order that kindly consider that analogy of Land Acquisition Act, section 49, pass the order till decision, you cannot proceed with the acquisition. That order was not at page 45, was passed long back. After that, they didn't do anything. They just challenged that order in a recalling application, my lord, which is pending since, my lord.
Recalling application.
Recalling of that order. 2004 order. From 2004, it was still pending, no steps taken by them. So, my lord, the proceeding lapsed in the meantime. As on date, there is no proceeding in the eye of law. This is the position. They have utilized my land, but the project has been set up in the land and the strip is lying useless. So they have to pay compensation for the entire land. Let them file a report in the meantime. I'll add the requiring body, but let them file a report. This is the position. So proceeding has lapsed.
On prayer of the petitioners, liberty is granted to amend the cost title of the writ petition by, you want to change this?
Yes, ma'am. Adding the Chief General Manager, BSNL, West Bengal Telecom Circle.
In addition to this,
I'll change this because he is no more there. This post has changed.
by impleading the
Respondent number 3, impleading the Chief General Manager, BSNL, West Bengal Telecom Circle.
BSNL, West Bengal
Telecom Circle. In place of respondent number 3.
in place and state of the third respondent. Paragraph. Learned counsel for the state respondent seeks to use a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading after vacation.
As a lordship. If possible, in the month of December, if they can, after vacation. Pardon.
Under the heading motion, 11 January.
Much obliged.
Pension matter shall be.
By course of this day, I'll make the correction.
Next.
Correction একটু পড়ো জুনিয়র তাহলে অর্ডার জুনিয়র আসছে একটু পরে আসতে হয়েছে I'm for the petitioners. I'm for the state, my lord.
So the prayer for consideration of the application, Lord, the what's application, my lord, Lord, kindly see the similar matter, Lord, since passed in order, page 35.
Consideration of application.
Yes.
My lord, only
Page 35
only one thing, my lord. Your lordship directed that the irrigation department will cause an inquiry. If they find that land is taken, then they will refer it to the land acquisition department. They will pay the compensation. Our only instruction is that the land acquisition department has not acquired any land. They say that so my lord, it should be before the irrigation department itself. Let them consider. Let them remark it. Only that part may be, my lord, modified. This is my instruction, my lord.
I'm not listening.
Second
I have
page.
stated that the land has not been acquired. Only position has been taken for the purpose of construction of the river.
So the land acquisition department doesn't come in the picture, my lord. The irrigation will come.
But only one thing, sir, for the payment of compensation, special land acquisition is also must have informed.
No, if there is no acquisition at all, my lord, if the irrigation department, then
after the inquiry report,
then it is the duty of the it is the duty of the irrigation department. If they have taken at all his land, the duty of that department to either return or, my lord,
oh, that's true.
take proposal or to send proposal or whatever, my lord. So that department has to do it. Right?
That should be informed. That is the thing.
Irrigation ki to bolte hobe, sir.
You are talking about this one, report shall be placed before the special land acquisition.
Only for
collector?
information.
Yes.
For information, it may be placed, but not the direction. So far as my lord,
I have no objection. All
so far as
this is
him, my
conducted
lord,
by the
paying compensation, my lord, that will possibly not arise unless the irrigation my lord starts the proceeding for compensation. So it has to be by the irrigation. Second page. That is my instruction.
That is, my lord, the all the things, my lord, all the inquiries conducted by the executive engineer, irrigation department. That's true. I have no objection to that. But for the purpose of compensation, they should be informed. And lordship passed an order, senior page 35. On that basis, my lord, the next page on inquiry.
Last 3-4 paragraphs, lordship says, my lord. Last 3 or 4 paragraphs from the field verification report.
Let me just add a line here. If the sixth respondent is the
Irrigation, possibly.
Six respondent irrigation.
they are directed to conduct the inquiry.
Inquiry.
So that's all right.
Now, if my lord, it is found that land has been taken by irrigation, then the payment of compensation is on.
Send the matter to the.
They will have to take.
Special land acquisition officer.
Yes.
Proposal sent to the, my lord, for direct purchase, my lord. All the lands of my landed friends, my lord, we have, give the compensation in direct purchase.
There are 3 ways. One, my lord, they might return the land. There are 3 ways out. Either return, if it is found, we have not yet found that his land has been taken. If it is found his land has been taken, first is, my lord, return of land. Second is, my lord, direct purchase. Third is fresh acquisition. So what steps shall be taken? That is, my lord, after, unless not the decision is taken, whether his land is taken, we cannot decide on that course. We have to adopt any of the 3 courses.
This order also says the same thing.
But the payment of compensation part, my lord, by the only.
It's found that the petitioners are entitled to compensation.
My lord.
Such compensation shall be paid within a period of 3 months.
My lord. By the land acquisition, but it has to be by the irrigation. The payment always comes from the requiring body. So land acquisition cannot, unless the irrigation gives the proposal and places the fund, land acquisition cannot pay the money. So let the irrigation responsibility be on the irrigation, my lord, because they have to take steps. Otherwise, we have faced this, my lord, in some cases.
Unless the
In some cases, we have faced this, my lord.
The remaining part of the order, let it remain as it is. Joint
My
verification
lord.
is fine.
Only last part.
What Ms. Banerjee says is the payment part.
Because what happens, my lord, the requiring body sometimes doesn't place the fund.
Right of that, here, report of such bill verification be placed before the special land. You play, my lord, that the 6 respondent sent a proposal. For
If it is found to be taken.
Then, my lord, the 6 respondent sent the proposal for paying the compensation in accordance with.
So I'll change from this part.
Yes, my lord, that part. Send the
No,
proposal.
your lordship will remember one contempt was taken up by your lordship where requiring body was not placing the fund. And the land acquisition officer was the contemptor. So much problem arose because of that non-placing of fund. Every matter. Sir, to question.
এই জায়গাটাকে mark করছি,
আমি তো আপনার সঙ্গে এই মামলাটা আছি জুনিয়া যেটা এই যে প্ল্যান তমলুকের পূর্ব মেদিনীপুর
সবগুলোই এখানে না এই স্পেশাল করছে কি হিয়ারিং থেকে আবার পাঠিয়ে দিচ্ছে এক্সিকিউটিভ ইঞ্জিনিয়ার টাকা না
In the event it is
ইনকোয়ারিটা
found that
করার জন্য
petitioners
পাঠিয়ে
are
দিচ্ছে সব
entitled to compensation.
অল দ্য থিংস ডান অ্যাকচুয়াল ঘটনাটা তো এখানে তো অ্যাপ্লিকেশন ডিসিশন হয়নি
406 আর 507
Sixth respondent will place the fund. The sixth respondent shall place necessary fund before the fifth respondent who shall disburse.
Lord, that if acquisition takes place, if not direct purchase, then there's no, so they will take necessary steps for payment or if the land is returned, then there's no question of.
For a moment, so far my little knowledge, last occasion all the matters have taken up. Only inquiry part is conducted by the executive engineer irrigation department. Not the that's so because here the land has not been acquired by a proceedings. Only land has been utilized by the irrigation department. That's why the land should be inquired by the irrigation department. After the irrigation department, it may be for payment. That should proposal placed before the special land acquisition for the purpose of to the valuation for the purchase committee. That was the last occasion order passed.
So it should take necessary steps for payment of compensation. That might be acquisition or direct purchase, anything.
Shall take
necessary steps for
Yes,
payment of compensation. If it is found.
In the event it is found that the petitioners are entitled to compensation, the sixth respondent is directed to take necessary
আর এটা তো
steps
ইয়ে
for
ফান্ড
payment of
গভর্নমেন্ট থেকে রিজার্ভ
compensation to the petitioner within 3 months.
In 3 months.
Yes.
No, kindly make that little
After the report, 3 months after.
little more. Kindly make it 4 months, because if they send a proposal, then the thing has to be completed. Kindly
all the things are going on. Some matters are also
Managed
proceeding.
purchase takes some more time.
it takes some time.
Because it has to travel to the cabinet.
I have not
It's
objection.
4 months from the date of receipt of the report. Upon giving reasonable opportunity of hearing.
Not report for the proposal.
Proper. That means
No. The verification report.
Verification report.
verification report ছাড়া তো proposal হতে পারে না।
And proposal.
The report need not be placed before the
Proposal.
They will take
session at
necessary steps. If necessary, they will send the proposal. They will, it's up to them. Within 4 months, they have to complete.
Report must along with the
4 months
proposal.
দিচ্ছে, 4 মাসের মধ্যে they will have to complete the entire thing. হ্যাঁ, demarcation টা হোক আগে।
চলুন না।
Demarcation কম আসে।
ডিমার্কেশন 3 মাস লাগবেই তো।
এটা দেয়া আছে বলা।
হ্যাঁ দেওয়া আছে।
from the date of communication of this order of the from the communication of this order.
পূর্বান্ত করা আছে।
হ্যাঁ করা আছে তো।
ঠিক আছে, আরো অর্ডার করতে। শুধু ওইটুকু করে দিতে হবে।
From the date of communication of this order of the parcel. Total.
পূর্বান্ত ছাড়া 2 মাসের মধ্যে পড়বে না, কারণ এখন তো ইয়ে সাগর মেলার জন্য 2 মাস কোনো কাজ হচ্ছে না।
But it is very.
পৌষ মাসে কিছু করবে না।
এটার পরে in the event.
যেগুলো পেন্ডিং আছে সেগুলো কমপ্লিট করছে।
In the event যেটা
কতগুলো টাকা দিতে হবে?
হ্যাঁ কিছু পোর্শন পেয়েছে, এখন রিলিজ হয়নি সব টাকা।
receipt of the
ল্যান্ড ভেরিফিকেশন করে
ওটা field verification report.
ওই কন্টেন্টের আওতায় সব টাকা পাইনি আপনি। only 1/3% পেয়েছে।
Concerned, including the petitioners, in accordance with law. But it's made clear, this court has not gone into merits, that is recorded.
Next matter is same matter.
I am what is it?
True. Every time.
Correspondent is also the same, 6th and.
Same matter. Every service. Same matter, every service.
Same order.
Yeah, stated নামটা চেঞ্জ হবে। চন্ডিদা
Same order.
আপনার নামটা
Same order, Mr. Dev?
Yes, my lord, I am for those.
পরেরটা আপনি আছেন?
There you go. What is the
My petition led. In fact, this is the second round of litigation, my lad.
Led by Mr. Washington.
My lad, the first round of litigation that you lost is passed an order at page 35. Picture কোথায়? এই যে
Yes.
Now they are supposed to let give hearing and take a decision in the matter. Now the genesis of the matter is at 47. For the first time, I have come to learn about all this when this plaque was opened on 2nd April 2023.
Yes.
For নলবাহিত পরিশ্রুত পানীয় জলে শুভ সূচনা করলেন। Now, after hearing Millet, they have given a reasoned decision as at page 49, and they says that they have requisitioned the land under the old act of 1948, and they have made payment to somebody else. Therefore, they have no obligations.
Who is this Nonibala Devi?
Milad, the person milad, who has milad, gifted me prior to acquisition, my grandmother. But I do not know, I do not have the notices, the acquisition notices, nothing has been disclosed. We have sought for specifically. The providers all this, nothing. Page 50, third paragraph, the petitioners claim that she was the owner of the aforesaid 1 acre land, which she had obtained from her grandmother Nonibala Devi as gifted in 1978. Can you mark the date? She also produced one deed of donation made by the grandmother Srimati Nonibala Devi in her favor. The land acquisition officer Murshidabad produced documents in respect of acquisition of the land in the year 1983. Subsequent, the land was recorded in the name of Nonibala Devi. At the time of acquisition, all legal procedures were followed. The acquisition compensation was given to Nonibala Devi at the time. The law requires to the owner notice, not the recorded, somebody in whose name that it is recorded. That the law is very clear. Kindly takes up the
thereafter the paragraph, the petitioner did not record her name in the land records.
No, not in dispute.
He did not produce any claim during the acquisition process. Kindly come to this paragraph also. Lord. And even said Srimati Nonibala Devi did not inform the land department about the gift deed she had made in favor of her granddaughter. So the land department was not aware as to whether there was any other owner of the land or not. As the government has already paid compensation for the land acquired, there is no scope of payment of any further compensation in favor of the petition.
That state's fault is
Change of ownership was
no.
Yes.
They are supposed to act in terms of the statute. The statute of 1940, I have two-fold of submission. Statute of 1940 kindly takes up the statute once.
Lordship, this is my
these
report. Have you served a copy to the petitioner?
No.
Please serve a
I am
copy.
serving. Lordship.
This for the first time, but I have come to learn with the plaque only. Now, kindly see
Yes.
the first act. Whereas, the preamble, it is expedient to provide the requisition and speedy acquisition of the land for the purposes of maintaining supplies and services essential to the life and of the community. And other requirements or are all requirements and for which the land can be requisitioned under this act is extreme urgency. Kindly see the year 1940 immediately after independence. The requirement emergent. That's the reason this act was enacted. Now, this act requires section 3. If the state government is of the opinion that it is necessary so to do for maintaining supplies and services essential to the life and community, then they have to, under clause 2, an order under subsection 1 shall be served in a prescribed manner on the owner of the land. And where the order relates to land in occupation of an occupier not being the owner of the land, also on such occupier. Then, kindly takes up section 5. Section 5, notice. Clause 3. Collector shall also serve notice in a manner prescribed on the occupier, if any, on such land and on such person known or believed to be the interested therein, or to be entitled to act for the person so too interested, as resides or have agents authorized to receive service on their behalf within the revenue district in which the land is situated. Now, all records are lying. Thereafter they have to serve to the address, last known of the resident address or the business address. These are the requirements. They have this statute has specifically divides occupier, owner. I assume the name whose name has been recorded is the occupier. He has to serve, as well as the person who is owner.
Will you come back with a report? Showing the document, will you come back with a report annexing the relevant documents?
Including notices.
As to
Kindly
all-
pass order as your lordship made it. I have already, my humble submission is that there is no scope to,
And if even if any malad they have paid wrongly to anybody else, I do not know. Malad, they can recover under the Recovery Act. Malad. Bengal Public Recovery Act, they can also always recover. And
Because they have received a copy of.
I do not know, malad.
Please
Malad,
go through this and come back.
I can.
lordship.
Yes. State,
Malad, it would be convenient for me, malad, if they malad, provide us the copies of the notification under which they have acquired. I do not know, malad.
is it annexed to your report? The notification?
Lordship, I.
No, apparently no, malad. Apparently no. No,
These are not award notices.
only.
No, I find a notification, annexure 3.
Annexure 3. Yes, there is a notification. No, no notifications. Yes, malad. Do you have an X under 3A notice? Let me go through it.
This is in the year 1978. Your date is annexed?
Yes, I have a next. At page 28. And they admit.
Please go through this and come back. Learned Council's statement of fact submitted on behalf of the state respondents is taken on record. Paragraph for learned counsels for the parties. Paragraph, let the matter appear under the same heading for further consideration. Come back.
Next week any day.
Lordship, after 2 weeks, kindly.
আপনার তো কিছু করার নেই।
কিন্তু অপারেশন হয়েছে।
December 1/8.
Lordship.
So they are carrying on construction. I do not stand with the development. I do not want to. Like,
Part has to be seen.
that's whether this acquisition will be still be valid or not, that is also subject matter.
Come back, please go through the documents.
But I am for the petitioner. This matter, though on the last occasion, an affidavit was filed. Although on the last occasion, an affidavit was filed indicating that my lord's order was complied with or had been complied with, but it fell from your lordship that a complete affidavit be again filed, that to what extent and how it has been. Now, my lord, the order was that initial order, earlier writ petition, and then my lord's order was that in this writ petition also, prior to that contempt proceeding, that the permit be given against that 24th vacancy on a particular route. It was their contention that their application was rejected on the ground of no vacancy, and according to their, my lord, the version was that no, the 24th vacancy was there, but it was filled up illegally instead of giving him. So this was the, my lord, the issue. Now eventually, my lord, that 24th against that, because otherwise no other permit can be given. It's a, my lord, the route, my lord, that is under section 713, a notified route. My lord, in any event, my lord, eventually, my lord, the RTA board cancelled after giving notice to that permit holder of that 24th vacancy permit holder that you have to surrender, and my lord, it has surrendered, cancelled, and against that vacancy, my lord, the present petitioner has been granted. He has been, my lord, accommodated, and my lord, permit also issued. So I think, my lord, offer letter issued. Now he has to place the vehicle according to the, my lord, the complied with. My lord, this is the, my lord, the compliance final report.
Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph, it appears from the affidavit and is also submitted by the
Annexure is the, my lord, the board resolution, one after another.
For the parties that
Page number 5.
the order under contempt has been complied with in its entirety. Paragraph, in view of the above, the contempt application being CPN certain such is disposed of. Paragraph, there shall however be no interest costs as in certified.
Okay. The contempt application is dropped. But the it's original? No, it's a copy.
511.
My lord, I am for the petition.
I appear.
My lord, this matter was heard previously, my lord. Then the state came out with a report, and my lord was pleased to fix it after vacation. Finally, this matter is being taken up. My lord, let me move this matter once again, afresh. My lord is pleased to take up page 46. This is the challan, my lord. And at the very bottom, after the table, the offenses are 3 in number: carrying excess load, driving dangerously, and plying without or invalid certificate of fitness. Now, point number 2 and 3, my lord, I am not standing in the way. I am not pressing, my lord. But the first one, carrying excess load, it says that a fine of 38,000 rupees has been imposed for that purpose. And in the remarks at the very end, it says that plying with 4x2 prime mover attached semi-trailer comprising 4 tire, 2 leaf axle, 1 pneumatic suspension. Thus, GVW, that is gross vehicle weight, should have been 46,500. Now, with this in mind, my lord, if my lord is pleased to take up page 13, which is my registration certificate. Page 13. There, my lord will find that the gross combination weight, it is gross vehicle weight, my lord, is 55,000. That is permissible for my vehicle. Now, if I take up the relevant section, it's section 113. Section 113, subsection 3 is the most relevant part. May I read out, my lord? No person shall drive or cause or allow to be driven in any public place, any motor vehicle or trailer, the unladen weight of which exceeds the unladen weight specified in the certificate of registration. This is not applicable for me. The next one is the laden weight of which exceeds the gross vehicle weight specified in the registration certificate. So in this case, my lord, what the transport authorities have said is that I am carrying, according to their calculations, I am carrying about 54,000, that is 54 tons. And my permissible limit as per my certificate of registration is 55,000, that is 55 tons. So I am well within the permissible limit. Now, my lord, the report that the state has come up with,
Flexibility also permissible.
there is a 5% flexibility,
5%
my lord. Now, my lord, what the report they have come out with, my lord, if I may be allowed to deal with it, my lord, now. In page 9 and 10 of the report, my lord, there are two government notifications. And both, my lord, will be pleased to note that are of 2018. Both are of 2018. And both of the notifications are issued under section 58 of the Motor Vehicles Act. And my registration, my lord, was in the year 2022. That is available from the certificate of registration at page 13 of my petition. Now, if I look at section 58, under which these notifications has been issued, hello, this subsection 1 says, the central government may, having regard to the number, nature, and size of the tires attached to the wheels of a transport vehicle, other than a motor cab, and its make and model and other relevant considerations by notification in the official gazette, specify in relation to the make, model, or make and model of a transport vehicle, the maximum gross vehicle weight of such vehicle, and the maximum safe axle weight and each axle of such vehicle. So the this basically provides for the notification. By notification, gross vehicle weight may be specified. Now, the next subsection, it casts a responsibility upon the registering authority. Subsection 2, a registering authority, when registering a transport vehicle other than a motor cab, shall enter in the record of registration and shall also enter in the certificate of registration of the vehicle the following particulars: unladen weight of the vehicle, number, nature, and size of tires attached to each wheel, gross vehicle weight of the vehicle, and registered axle weights. So, this casts a responsibility upon the registering authority that, as per the notifications that has been issued, the gross vehicle weight should be reflected in the certificate of registration. The next subsection, my lord, subsection 3 of section 58, there shall not be entered in the certificate of registration of any such vehicle any gross vehicle weight or registered axle weight of any of the axles different from that specified in the notification. So this is a negative responsibility, my lord. So basically what this subsection says is that whatever has been specified in the notification and whatever is reflected in the registration certificate, the registering authority is responsible for ensuring that there are no discrepancies.
And your registration certificate doesn't bear the maximum safe axle weight at all.
No, it bears only the unladen and gross vehicle weight. Gross vehicle weight is the bone of contention here, my lord. And gross vehicle weight is very much reflected. And it is the responsibility of the registering authority, that is the state, to ensure that there are no discrepancies. So now, by the report, what the state is effectively doing is they are contradicting their own notification and the registration certificate which has been issued by them only. In the registration certificate, state says that 55,000 is permissible. And in the report, they say no, it's not permissible. And more importantly, the transport officer says that only 46,500.
Let the state answer in. So the notification deals with maximum safe axle weight,
Safe axle weight.
which is
And-
not equal to the gross combination weight.
And also, my lord, in page 9 of the notification, point number 2. Point number 2, my lord, the gross vehicle weight shall not exceed the total permissible safe axle weight as above, and in no case shall exceed, then sub point number 2, 55 tons. In case of semi-articulated trailers, truck trailers, except.
So this is applicable in your case.
This is applicable in my case, my lord.
And 55 tons is your gross combination weight as per your
Yes, my lord.
registration
Yes, my
certificate.
lord.
What was the
And the transport officer says that no, it should be 46,500.
where is that said?
My lord, in the challan itself, page 46, my lord. At the very bottom, my lord, remarks. It starts with remarks.
46,500.
GVW of the vehicle should have been 46,500. This is where the transport authority is overstepping its jurisdiction, my lord. It's going beyond the statute. Because statute provides whatever is specified in the registration certificate, that would be the GVW. Now, an officer cannot say that it should be less. And as my registration is of 22 and these notifications are of 2018, it is deemed that my registration certificate has been issued in consonance and in conformity with these notifications, my lord. These notifications were very much in force when this registration certificate was issued. That is my contention, my lord. My lord, we have already paid the fine, so our prayer is for a refund of this.
For refund. Yes, Mr. Devra.
Yes. Let's turn to my report. Page 3, paragraph 6 on.
Yes.
Apparently, it appeared to the concerned enforcement officer when first paragraph submitted the Caesar paragraph 5, I am skip over this paragraph. Then 6. Apparently, it appeared to the concerned enforcement officer that the said vehicle was carrying excess load over the permissible load. Upon scrutiny of the documents so produced, it was found that the gross vehicle weight of the said vehicle was 54.79 kg, that is 54 tons transfer, whereas the permissible weight as per structural specification of the subject vehicle should have been 46.500 kg.
This is
Thus,
arbitrary. From where do you get this 4650?
I am coming. Thus, the subject vehicle was about more than 9 tons above the permissible weight. It is, I am coming. It is further submitted that upon further physical verification, it was found that the said vehicle was flying with 4x2 Sigma Tata Signa 552 5.20 square along with a semi-trailer comprising one pneumatic suspension and two mechanical lift suspension axle. Upon physical measurement of the 3 axle of the subject vehicle, following details were found. Then, A, the in between distance between first R1 and the second R2 axle is 1.55 meter, and likewise the in between gap between the second R2 and the third axle is also 1.55 meter. There is one fitment pneumatic suspension on the first axle and subject to axle. Next, yes, which is not totally contrary to the central motor vehicle specifications as mentioned in the central motor vehicle rules. Well, next, my lord, it is stated that in terms of notification number 16 July here, my annex, my learned friend just now issued by the Ministry of Finance, the combination of gross vehicle weight of said type of vehicle should be
46.500 kg. In this context, copies of the here. Furthermore, paragraph 9 is vital matter. Furthermore, on perusal of the data in respect of the subject as retrieved from Bahon 4 online database, it transferred that the said vehicle is registered with Regional Transport Officer Howrah and gross vehicle weight of the said vehicle has been shown as 54 kgs that is stored. Distributing axle weight as 7 kg, 11.5 500 kg for prime mover, 11,500 kg for tandem axle and 24,000 kg for other axle attached with the semi-trailer, which is completely in contravention of the notice issued by the Ministry of Road Transport. Then, my lord, Lordship kindly see paragraph 10, the gross vehicle weight or gross combination weight of 54,000 kgs can be maintained to an articulated trailer only on observation of certain specific configurations which are enumerated here below. Then, my lord, that is the gap or technical, all are technical here. In paragraph 11, Lordship kindly see. It is also submitted on inspection of the combination of the axle and wheels of the subject vehicle. It appears that the said vehicle differs from the vehicular specification as mandated by Ministry of Road Transport and Highway Government of India. Gross combination weight of 54,000 kgs or 54 ton of a vehicle should only be permissible when the distance between two axles should be 1.8 meters or above, but in the subject vehicle, the distance between two axles was found as 1.5 meter, which is much lesser. Thus, the carrying capacity of the vehicle differs in comparison to physically seized vehicles and the data available in respect of the said vehicle on the Bahon portal. In the present case, it can be presumed that while assembling the same semi-trailer with the prime mover, the specification mandated by the Ministry of Road Transport and Highways in that regard was violated by the replacing the existing specification. Hence, the certificate of fitness of the subject vehicle is not effective. Moreover, the said vehicle was found to be carrying extra load. But no exceptional till date, but no denial. Till date, no delay. It is not permissible under the law.
Frankly speaking, I do not follow the language of what your report says. Basic thing is registration certificate issued by the authority. It shows 55,000. The weight, the load was less than that. So where is the difficulty?
What happened, my lord, here, my lord, mainly tailor is concerned. They produced one tailor before the registering authority, only tail portion, only race portion, but and they after registration, after got registration, the tail has only changed. Second part has been changed. That is my case.
How is that possible?
My lord, this is like claiming benefit of their own wrong.
That is Caesar was made.
Where have you stated that it was changed subsequently? There is no allegation.
My lord, this
In your
is
report, there is no allegation that they have changed the trailer subsequently.
my lord, this is like claiming benefit of.
Contravention of the provisions means that change at the time of registration.
It doesn't mean at all. What change? What steps have you taken for change? That's illegal. There is no averment that they have changed the trailer subsequently, which is a difficult situation. Registration certificate says permissible weight is 55,000. It was below that. So how can you charge this? And your axle and all, that's nothing is stated in the registration certificate. From where did you get all
That
this?
is the difficulty, my lord. That is, I have also.
So if that is the difficulty, then the petitioner gets the benefit. You have to return the amount, refund the amount. You have not been able to prove.
Then, my lord, logically passed necessary order. Lordship kindly grant me liberty to take appropriate steps for appropriate steps
For what?
for registration. Registration is concerned. Because I have to.
Which registration? It has already been registered.
No, registration is concerned. After registration, this thing is happening.
That's not your case at all, and this is not your writ petition.
This thing is happening now.
That is, you can come up with a writ petition afterwards. In this writ petition, it cannot be considered. It's very clear. It is below the weight stated.
It only see that whether it is violated or not.
There is no violation. Where is the violation?
That
Your
is
report does
anomaly.
not explain anything.
This is by anomaly.
Where is the anomaly?
This is found that anomaly.
Where is the anomaly, sir? I do not find any anomaly.
This is anomaly.
Registration says 55,000. He is below 55,000.
Regarding specification is concerned under
Stated in the registration. How is he supposed to know? It should be in the registration certificate, the registration of the vehicle then. This axle and all that you have stated, all technical terms, the code doesn't follow.
That is the technical term.
I do not follow any of the terms. And your report is very vague. I cannot follow anything that is stated in the report.
Technical point.
From one axle, two axle, one wheel, two wheel, I do not follow.
That is
We know that there are a
I
number of
also
wheels.
feeling difficulty there. So technicality is there.
Yes, so
If any technical defect is there,
so
then
for the timing, you have to refund the amount. If you want to take steps, you can take steps later on. There is no violation.
and we can take steps accordingly.
You can file a
That liberty need not be given in the order. That's available with them.
And I don't think even I
All
will give you
54 ton,
opportunity.
no,
I
as
don't
per
think
ye.
you can clarify this. Can you?
Logically give
My lord, already
No, it's already deposited. Already deposit. Vehicle has been released. Now,
Because
no
this-
urgency is
I
there.
don't find any meaning of I at least with my limited knowledge of all this, I cannot follow what's stated here.
I shall file another report without technicalities. Only with
the statutory provisions are totally in our favor. And what they are saying is like they are claiming benefit of their own wrong. If I stand with their submission.
They have not filed any exception or reply that it's.
It boils down to the simple thing, registration, it is not in violation of
the
the registration.
That is the difficulty.
Registration was granted by the authority. He is within limits of the registration.
That is the main difficulty, my lord. At J1, I told the officer.
And a layman is not supposed to know about all this wheel and
They are
axle and all
concerned that
this.
they have already got registration 54 so. How can he seize the vehicle? Then mala he stated so and so. I don't know.
He has stated, I don't know what.
That is,
Yes.
this is the difference between paper and practical. They are on the practical field, technical inspectors.
So let me meet the difference on paper. Yes. Let it be disposed of.
My lord, I am for the respondent number 5, manufacturer. My lord, as per ARI, that is certificate is with me. That is 54,000.
Let me first understand whom are you supporting, the state or the petitioner?
No, I am for the petitioner. I am supporting the petitioner.
You are supporting the petitioner. So, Mr. Debra, bad luck for you. He's also supporting the petitioner. Yes, what is your submission, sir?
My lord, as per ARI certificate, the Tata DLT 40 feet 3, that is 30, serial number 139.
At page?
That is not, that certificate is with me, my lord.
Oh.
That is with me, my lord. That is 54,000. I have no copy at present.
I think.
Copy.
Yes, you say that gross weight is 54,000, but he has exceeded 54,000.
54 exceed. Yes, but then I have the 5%.
They are issued the permission already given, tax also taken for 55. That is the problem here.
I'm not on that, my lord, but there is the 5%.
Yes.
According to the notification submitted by the state.
Yes, Mr. Debra. Let me pass an order for refund.
My lord.
I leave it to your
Sorry. No, no,
Lordship only,
Yeah,
my lord,
really?
only the. Lordship only record that my lord is not gone into the.
Gone into the?
Merit.
No, 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 no. What is the very
I am
definite
the
otherwise Lordship pass on order. Regarding anomaly is not. Regarding anomaly.
I do not have the knowledge to decide
I am-
your report. I cannot
That is
follow
why,
line of.
that is why Lordship anomaly is.
টেকনিক্যালটা পড়তে যাইনি সেটাই বলতে চাই যেহেতু সার্টিফিকেট নিয়েছে এটা করতে এইটাই হচ্ছে
Petitioner was slapped with a challan of rupees
অনেকবার চেঞ্জ করতে
53 was the total amount, but for this it was 38,000.
3-4 grounds. Colon dash. I carrying excess load
বললাম তো এইটার জন্য 38
within bracket 5 rupees 38,000. I driving dangerously within bracket fine rupees 5,000 and I flying vehicle without or invalid certificate of fitness within bracket fine 10,000. The petitioner challenges the fine imposed for carrying excess load. Paragraph. Learned counsel for the petitioner takes this court to the registration
ফিটনেস হয়েছে বলে
certificate of the vehicle in question, which demonstrates that the gross combination weight of the vehicle should be 55,000 kilograms
ফিটমেন্ট জোড়া লাগে ইন্স্যুরেন্স
the said weight was found to be 46,50
না ফেরত দিন চেঞ্জ রেজিস্ট্রেশন কিলোগ্রাফ
by the motor vehicle inspector, for which the fine was imposed. Stop. Paragraph.
national
Learned counsel for the state respondents has placed reliance on the report in the form of affidavit submitted by the second respondent, which contains notifications of the Ministry of Road, Transport and Highways issued on 16th July 2018 and 6th August 2018. Stop. The notifications deal with axle types, AXL, axle types of several categories of vehicles. Stop.
Senior RC type fitness certificate. Type requirement of the fitness certificate.
পয়সা নিয়ে যে 18 সালে কাম করছে তাহলে 20 সালের থেকে 18 সালের কাম নেই বুঝছি সাবমিশন সুন্দর করে দিতে
None.
The report is contradictory. Once it says that since the gross vehicle weight of the seized vehicle was
Okay, 54 is also the same. No, no, era. No, era কি করবে? না, এরা carry করছিল যেটা 54 point. ও, তাহলে একটু একটু জায়গা 7 if I believe them. What precision do they have?
the report deals with vehicular specifications and other technical issues are not explained. Stop. Paragraph. As enumerated in section 58 within bracket 2, in section 58 of the Motor Vehicles Act 1988, the registering authority, while registering a transport vehicle, is supposed to record the unladen weight of the vehicle, the numbers, nature and size of the tires attached to each wheel, number, nature and size of the tires attached to each wheel, and the gross vehicle weight of the vehicle, and the registered axle weights pertaining to several axles there. Stop. The registration certificate
দর্শক তো ঢুকতে চাইছে না কিন্তু টেকনিক্যালিটি মেকানিক্যাল পুরো ইঞ্জিনিয়ারিং টার্ম
records that the gross combination weight of the vehicle is 55,000 kgs, 55,000 kilograms. They say number of axle is 5. Does it have
How many axles?
Tri-axle.
Tri-axle one.
Tri-axle.
Three-axle. Three-axle one.
Since the gross vehicle weight of the vehicle was found to be 46,500 kilograms, that is
এটা বলা যে tri-axle.
below the registration certificate, it cannot be said that the vehicle was carrying excess load at the relevant time. Fine of rupees 38,000 imposed upon the petitioner for carrying excess load is arbitrary and without any legal sanction. Paragraph, in the said backdrop, comma, this court is inclined to hold that the amount of rupees that the concerned authority, comma, who should return? The motor vehicles inspection.
My lord,
আসানসোল চালানে আছে।
চালানটাই
He is not made a party.
না না এটাই চালান।
Not made a party. The regional transport officer.
তাই তো মানে রামপুর তো আলাদা আছে
স্টেট অফ
রামপুর চেকপোস্ট
This was issued by the MVI non-technical.
এমবিআই নন টেকনিক্যাল মানে রামপুর চেকপোস্ট
My lord, respondent number 2, I think. Regional Transport Officer, Paschim Bardhaman. Sripolli Post Office. Bardhaman.
বর্ধমান
পশ্চিম বর্ধমান
পশ্চিম বর্ধমান
The second respondent herein be directed to refund the amount of rupees 38,000
আসানসোল
already
ইয়ে দিয়ে ওটা বলা নেই।
by the minister. Within 2 weeks.
3 weeks.
It take in 1 day. So 2 weeks sufficient. The amount is taken in 1 day. So 2 weeks sufficient.
Who is date of communication of
Within 2 weeks from the date of communication of this order. আচ্ছা একদম শুরুতে একটা লাইন
38,000 না
deposited the 30,000. The parent. Has already set up for the other. This was the
My lord, one indulgence, my lord. The officer who is supposed to return, my lord, Regional Transport Officer, Paschim Bardhaman, my lord, may kindly specify Asansol there also. Because it is in Asansol actually. Paschim Bardhaman.
has
If-
been included.
Specifically, Asansol has not been stated here.
Then?
But Sripolli Post Office, that's under Asansol.
Asansol has not been made a party. This is
So, my lord,
Howrah.
respondent number two is the same person. Only Asansol has not been specified. The PIN number and the district and also the post office, they are all under Asansol.
Not Paschim Bardhaman.
Paschim Bardhaman, my lord, is in Asansol itself, my lord.
Yes. It is in
Asansol.
So this should suffice.
My lord,
Covers
that would specify.
Is office at Asansol.
Office at Asansol.
Not necessary.
Then it's fine.
The
Then it's
designation
fine.
is this.
Then it's fine.
এই কাগজটা
Any
512.
Grateful, my lord.
For the repetition in this matter, my lord. So you will remember this is a matter, my lord, where I have prayed
for intermediate loading after execution of the contract. And there is a railway board circular to that effect, which I have relied upon in the previous hearing.
Yes.
My lord, which gives us, which gives the authority to the zonal railway, my lord, to incorporate necessary amendment prospectively, to include those stations where I am seeking intermediate loading. Now, my lord, on the basis of that, my lordship directed my other learned friend to take.
Yes, my lord, the thing is this, my lord, your lordship's direction was that on 3rd of October to take instruction from the authorities. My lord, my junior wrote later on 16th of October, and till today, my lord, we have not received any instruction. That's why, my lord, I am praying another fortnight time so that we can write again to give us the instruction very urgently.
My lord, yes, that is okay. My lord, only one thing, lordship, kindly one line order, my lord, with regard that the stations which I have indicated, it's very much appearing in the report of the railways. So that is there with them. Now, lordship, kindly direct them at least to know whether facilities does exist for loading and unloading over there. If it does exist, then as per this circular, my lord, I am entitled to, because it does not involve any finance. Lordship, there is a report, my lord. It's a report.
If it is there, my lord, then my learned friend will
A
get the
report may be
facility.
filed, my lord, so that I can take. Yes.
Yes.
Let it be after vacation, my lord. In the middle, let them file a report, my lord.
Council for the railways
Reward the
seeks
legal.
extension of time to submit a report in the form of an affidavit in
Yes.
this matter. Paragraph, let the matter please serve an advance copy.
Advance. Yes, yes. Yes, my lord.
And
Will
please
serve.
annex all the relevant documents. Matter, annexing all relevant documents at conclusion. Annexing all relevant documents. Paragraph, let the matter appear under the same heading on 18th January. Oh no, sorry, 2nd of 19th January.
Lordship, only one thing, my lord. Lordship, let them come up with a specific report whether the loading unloading facility exists over there or not. Because if it exists, then I am there through this
Oh,
circular.
my lord, if it is there, my lord, it will be report. It will be in the report.
Report will be a comprehensive report. Next.
Grateful.
513.
No, I am for the response when I take the preliminary point regarding the maintainability of the petition. I take the preliminary
Point of maintainability.
preliminary point, madam, regarding maintainability of the petition.
Mr. Singh is appearing. Since he is challenging maintainability, he will have the first right of audience. Yes. Yes, Mr.
My
Shankar.
lord,
On the maintainability point.
my lord, the petitioner, respondent number 7 is my client. My lord, he is having a blind permit. He has been operating vehicle. My lord, the petitioner and the respondent 7 might have a private relationship, but with regard to the grant of permit operational vehicle, there is no such relationship.
Challenge to the.
He has challenged my permit, praying for cancellation of the permit with the authority. I don't know how he can come to the court with a prayer, such prayer, under which authority is not a public interest investigation.
He is affected by the permit.
No, no, not at all, not at all. He is not anyway affected. Might have private relationship, but that does not affect the grant of permit or personal vehicle.
That has nothing to do
But yes, my lord, that is my prayer, my lord. I think, my lord, my learned friends should also consider that.
Reasons on the basis of forged documents.
But that should be considered, that has to be considered by the authority. They granted permit, they registered the vehicle. Now he is taking advantage. What he has done? No. Wow, must have the locus standi. You must have a locus. Writ petition.
Let us hear the.
Yes. Let him establish legal right.
Yes, I placed relevant documents are required to be placed. Because I have come with a clean hand, honest and transparency.
Primarily, what is your legal right infringed by way
Legal
of
right
grant of
infringed, my lord,
permit?
I have purchased the
Right,
vehicle.
respond.
Because respondent number 7, I am the valid operator on this road of another road. My lord, now the private respondent, he see of the operator on any other operator in respect of the operation.
In the same route?
She approached me.
In the same route?
No, another route. But she approached me to sell the vehicle to me.
because due to his suffering, she is suffering from financial crisis. I agree. I purchased the said vehicle and handed over all the documents. Form number 2930, because both the transfer and transferring, joint declaration declared for transfer. Therefore, agreement was executed. In the sale agreement, I paid the entire amount. Paid the entire amount. Then she handed over all the documents. Form number 2930. I placed them before the authority. Now the authority informed us that vehicle, my lord, is a petrol driven vehicle.
That vehicle is?
Petrol driven vehicle. Petrol. Now in the year 2011, because this that incident was happened in the year 2011. Well, in the year 2011, the Environment Department, Transport and Collaboratively, state government adopted policy that no petrol drive will be allowed to ply on the roads in respect to auto rickshaw, and that will be converted from petrol driven to 4-stroke LPG driven vehicle. That on that condition, that if you place this vehicle, then transfer of permit will be allowed. If the transfer of vehicle will be allowed. Then another agreement was executed with the private respondent because he has no money. Again, I have to purchase, I have invested the money to purchase the new vehicle. So that after purchasing the vehicle was placed before the registering authority, and vehicle was registered in the name of the respondent number 7. So I have invested the money because I have purchased the vehicle. Thereafter, the respondent number 7, she lodged a complaint before the police authority regarding the custody, because vehicle also handed over me after registration because I purchased the vehicle. Then, my lord, can you see that
the vehicle was purchased in exchange of the earlier vehicle?
Yes.
The petrol vehicle.
Yes, I hear. In the earlier vehicle I purchased, I invested all the money.
Registered in my name.
Registered again, my lord, I have purchased, I have invested the money for purchasing the new vehicle. Only the new vehicle, they purchased, the old vehicle will not be replaced. So I have invested twice.
So you've done social service.
Yes, I invested the twice. In the agreement I have annexed everything, I see agreed. Now he raised the comment, lodged a complaint before the police authority because the earlier documents all are forged. For this reason, she is very reluctant to appear before the authority because joint declaration is required before the authority, because address proof, everything, documents are required. For the, after hearing both parties, then vehicle was transferred. Now he lodged a complaint before the police authority under section 420, 468, 4971.
Yes,
420 yes, that matter is pending regarding custody. The vehicle was under my custody, pursuant to the direction of this on the court, London court below. The vehicle was handed over to the petitioner. As per concern allowed, I lodged another complaint on the sole ground criminal breach of trust under section 406. That documents that if I have copy, I have annexed. On the basis of that, 2 parallel proceedings were pending before the court regarding the possession of the vehicle. So far, the complaint, my lord, for cancellation of registration, that I raised the complaint before the registering authority. That application is pending before the authority. So for this reason, my lord, I have come before your lordship for consideration my representation, because that because I imposed along with this representation, I always imposed all the documents.
Why have you asked for cancellation of registration?
Because all those documents forged. For this reason, my lord, this one over 7.
You have taken steps for forgery of the documents?
Yes.
You filed a forgery case?
No, that's pending before the authority, before the district court, the criminal court.
It's criminal breach of trust.
Breach of trust.
That's
regarding the possession of the vehicle. So far the cancellation of registration, that I approached before the I expressed my grievance before the registering authority. Registering authority.
Is the registering authority in a position to do it before the criminal cases are disposed of?
Regarding possession of the vehicle. Regarding the possession, because the vehicle was custody in my custody. Now, in terms of court, I have handed over to him.
You have complaint forgery also.
Already on the why forgery case? Actually, at the initial stage, the vehicle was registered in the state of Bihar. Now, as per no objection certificate, the vehicle was brought in the state of West Bengal in the district of Havra. Now, in the name of the husband of the respondent 7, he has brought in the name of the NOC certificate. I have enclosed the documents and sheet it will very make picture will be clear. Page number
The
26.
registering authority.
And now
what
they
the
are
police force will not
vehicle
be
was
able
not
to
transferred in the name. Vehicle was transferred in the name of the police, response number 7. And permit also issued eligible. Now, my lord,
Mr.
that
Khan, you have to prove
after
the
the
forgery
document
first.
verification of website, that vehicle is already flying in the state of Jamshedpur, in the state of Jharkhand.
Prove the forgery first.
Forgery
Then
number
only the report
response
will
number
be
7,
sent.
response number 7.
Have you
But
filed?
that issue are involved. But here issue I have question, I have made a representation, and this is a representation of what?
You cannot make any representation before the authority.
Authority consider representation. I am not paying for mandatory
How
order.
can the authority consider your presentation? Your ground is forgery.
No, forgery means what? On the post document.
That is what it means.
On that, on the custody, regarding the custody of the vehicle was that issue involved in the lower court, in the court below. Here in this case, there is a provision. If there is a court and
Forged or not has to be decided by a competent court.
there is also provision. If there is any vehicle is the transfer on the basis of post document, the registering authority, the statutory authority has right to
that the documents are forged.
Yes, I have to prove everything. I have enclosed all the documents in the
Enclosure
representation.
doesn't prove. You have to prove, substantiate them by.
Unless take up the verification of the document, the authority will come with the conclusion after verification of my paper. I have already enclosed all the documents, which was handed over to me. The verification. For this reason, my lord, at the initial stage, vehicle was not transferred in my name. Even I have invested all the entire money. So, my lord, that is what I made the representation that representation will be considered against law, nothing else.
Vehicle has been registered in my name. Permit has been issued by name.
Both parties, you see.
Learned court below, my lord, granted, passed an order giving possession, custody of the vehicle in my favor under section 457 of the CRPC. My lord, everything is there.
I have annexed all the.
Now he has been making all these things every time.
I've invested twice.
Without going into, let us hear the state first. Yes, Mr. Sen.
I invested twice. I very much praise.
He has no right.
I'm the small operator. I invested twice.
Unless he finishes. I know that.
I invested twice.
Quarrel between two friends.
All right, fighting for the interest.
After all, it appears that my lord, two separate cause of action. One is with regard to forgery. That Mr. Samanto's client committed the fraud or forgery with regard to that registration purpose. The documents and whatever the papers submitted for the purpose of registration, that was not, my lord, the genuine, and or registration should not have been done on that basis. One is this, the issue. Other issue is that with regard to the said vehicle, an agreement for sale and or it was, my lord, entered into, some agreement entered into, my lord, between the private respondent and the petitioner. And that agreement having not been finalized or before finalized, in, my lord, practically the owner of the said vehicle transferred the same to other person, and eventually that went to Bihar and then again come to West Bengal, and the registration number got by way of fraud. Now, my lord, so far the forgery or fraud is concerned, those, my lord, the judgment are not with me right now, but there are several judgments of our High Court and the Supreme Court also. But our High Court several judgments that fraud or forgery cannot be looked into or go into question in a writ jurisdiction. Writ court cannot go into that question, fraud or forgery. It's a settled law.
It has
So,
a separate provision also.
There's separate provision. And so registering authority also cannot go into this, that whether this document was genuine or not. Registering authority, they have no such power. Apart from that machinery or other thing, they have no power at all. So that question goes. Now the remaining question or other issue is this, whether that, my lord, it's a, my lord, that the, my lord, breach of trust.
Breach of trust is a criminal matter. It's not here.
Another thing is breach of trust criminal matter. At the same time, so far civil remedy is concerned, that they entered into an agreement for the purpose
That
of
is the
transfer.
subject matter of the writ petition.
That is also, that also cannot be gone into. So what relief can be, my lord, given in this, my lord, petition to the petitioner?
At best, there can be a direction to consider the representation.
No, then again, my lord, that will generate another writ petition. When I would naturally answer that it is not my jurisdiction to go into this. So kindly consider. Because, my lord, one day, my lord, I also submitted before a lordship that it is the, my lord, that order is not with me, my lord, that the division bench judgment of our High Court, that anything and everything may be in the representation.
Cannot be
But
considered.
read court cannot say that representation should be, my lord, considered by the authority. Unless he says that he has a right to say so, and the authority has also obligation to consider the same. Neither, my lord, he ventilated, he has right to bring it to the notice of the court or to the authority. Nor he say, my lord, the section or my lord, any rule that yes, authority has right. Because when the fraud, can you consider one?
My lord, I have the place.
Let him complete, please.
Fraud, my lord, how can I go into this?
But the which permission the authority has right to consider? Representation, I think.
And already, my lord, he has, my lord, taking recourse to another, my lord, the proceeding, that is the criminal proceeding, that is pending. He has to wait for that. And when the criminal proceeding is there, the criminal court is in session over the matter with regard to the same issue. Whether any other, my lord, I think that, my lord, the quasi-judicial authority, the registering authority at best can be said, my lord, quasi-judicial authority. When before the judicial authority it is pending, how quasi-judicial authority can take up the matter and come to a final decision? Yes, it's a fraud. It cannot be.
Yes. Mr.
But it admitted fact that I have invested a lot of money. That all the documents were handed over.
Can the authority
All
deal
the
with
documents
this?
were handed over. The authority will check up. I have annexed all the documents.
What is the provision?
The law says, my lord, cancellation of the registration. If it is done by on based on the fraud.
Section?
My lord, there is a Motor Vehicles Act.
But fraud has to be established.
Yes, I said, what will take the decision by here?
How
Then I said,
authority,
I
how it can be established before the authority concerned?
I will reject my prayer. The agreement I know, it's a private document.
Yes, please show me the relevant provision.
Relevant provision of section 55.
Yes.
What has got
Yes, 55.
section 55, you cancel some operation. And also cancel some.
Not a 55, my lord.
We were put 55.
Yesterday, there is pending concession to the criminal court.
That regarding the position, I have said so everything in the representation. As rules and everything I have disclosed. And all the documents already pending. Document and also place the document that the same vehicle still flying in the state of Jharkhand.
Mr. Sen, please come to 55 clause 5.
My lord. Yes, yes, that is there. If it is registering that, to that extent, that power is there. But here the question he has already recourse. কোন প্রবলেম কি বলতো তোমার নিজের উপর কোনো কনফিডেন্স নেই হাত পা ছড়ছো খালি now the whole thing is that before coming to the writ court if a person choose to go before another appropriate court of law for remedy and that is with regard to fraud.
No, he has not gone before with regard to fraud. He has his complaint is breach of trust, not fraud.
But that issue already there, conjoined.
The breach of trust has no provision. 55(5) does not say so.
No, the this is on breach
But
of
there is a civil dispute. That may be a civil dispute.
trust.
Criminal,
May I?
that is pending business
May I read
with
out?
criminal court.
May I read out? If a registering authority is satisfied that the registration of a motor vehicle has been obtained on the basis of documents which were or by representation of facts which was false in any material particular.
This is the case.
Yes,
This
that is
his
there.
case.
That is there. But
So let the representation be considered. This is his case.
very good, my lord.
And he has not taken any steps for fraud before the
Not before the authority.
The matter is pending before the criminal court.
breach of trust, not on fraud.
No,
It's a different issue.
your lordship, then your lordship, what is his locus standi? How does he come? No. He has to come. He has to establish his right. Under Article 226, so far my knowledge goes.
It appears that yes, there is a provision. They have authority to enter into the same and determine the same. Then I leave it to your lordship.
But after hearing both
says.
No. Why?
Sir Shamunto, why is your client apprehensive, scared? Let the authority consider. I will not go into merits at all.
Mr. Kindly see. What does it say? How is he interested? In my permit, in my vehicle. He wants to grab that property. Can he do so in the writ court?
Definitely interested, Mr. Shamunto.
He has lost the complaint. He has gone to the criminal court.
He has some interest in the
By this point, the vehicle has been registered.
The representation is disposed of.
Representative.
Why is your client shying away from this?
Because vehicle is registered, permit has been granted. Kindly see. Permit has been granted. Your lordship, kindly see.
Yes.
Page 48.
That is being challenged. Let the representation be disposed of. Let the authority.
That is, your lordship, kindly see. That was in 2012. No. Your lordship, 2012. He is coming in 2023. No. Your lordship, kindly see. The permit has been granted in 2012. He is coming in 2023, challenging the grant of permit. Renewal after renewal. If your lordship entertains this petition, my lord, kindly see page 48. P copy 006 by 2 of 2011-12. Kindly see. And after 12 years, he is coming to the court, challenging the grant of permit.
Invested the money, this purchase of vehicle, that vehicle endorsed in the permit, new vehicle, I have invested the money.
That was in 2012.
There is also provision by
How do you explain the delay?
Yes.
How do you explain the delay? How do you explain the delay?
Delay, well, I have got the judgment, I am placing this. But delay means, my lord, the issue involves the illegal grant, illegal registration of the vehicle. So, my lord, there is no question of liquidation. Because no amount of passage of
Yes, but you can explain the delay.
Yes, explain the delay or the matter is continued because matter was placed before the so many take place. Ultimately, the malord are waiting. They are not calling.
What is the explanation in petition? What is the explanation in petition?
One case I brought the judgment of the division bench. Even after 8 years.
Bring judgment. Bring the judgment. Show before the court.
Yeah, in this case, the vehicle was registered on the basis of the illegal because he purchased the chasing. Very next day, vehicle was registered. Then one existing operator, and that permit also issued against that vehicle. Complaint was lost after 8 years. Then kind observation page number. Page number 3. Report paragraph. Report is site of the intention service. Paragraph second paragraph, page number 3. Complaint more than 8 years old. Next, fourth paragraph. The court will exercise of the jurisdiction should not involve itself hearing a complaint with regard to the alleged illegal issuance of permit. Since the issue involves alleged illegal issuance of permit, we do not think the question of limitation is very important here. Because the legal permit continues to remain illegal. Here, this is a very representation. I'm stated everything, documents have been annexed. After having both parties, my underfriend client will get the opportunity to make.
Why are you inviting me?
But because I ministered twice.
No.
I have somebody, I paid you.
How are you rejected?
After getting the money.
2012,
Getting the money, now he's playing the.
represent 2023. After 12 years.
Please give him the judgment. It is explained here.
Yes.
He can.
Well, I shall bring the judgment, my lord.
An illegality.
Yeah. But he'll get the opportunity to play sufficient.
I know, Mr. San, don't advise me.
After taking the money, now he is playing the game with me.
Game played by you.
In one case, my lord.
I am the victim of your game.
Play the games before the authority when you're hurt.
No. Why better? No. After the criminal court চলছে. One matter is going on with the criminal court.
My lord, it's a settled law.
Criminal court, my lord.
That in case of fraud or in that, my lord,
There is no limitation.
neither in criminal court,
This is, and this is alleged fraud.
Well,
Representation will be considered by the authority. You'll be given an opportunity of.
Just after he both.
For learned counsels for the parties. The petitioner seeks consideration of his representation submitted before the concerned authority on 14th June 2023. Paragraph. Learned counsel for the petitioner submits that the private respondent has obtained a permit from the authority by placing forged documents and practicing fraud upon the authority. He seeks cancellation of the permit. Stop. Sorry. It appears that criminal cases are pending by and between the petitioner and the private respondent on the ground of breach of trust, cheating, etc. Explaining the delay filing the writ petition. The learned counsel for the private respondent submits that the permit was granted in 2012 and the inordinate delay in filing the petition has not been accepted. Paragraph. In explaining the said delay form, learned counsel for the petitioner relies on a judgment passed by an honorable diction which is 496 of 28 on 8 June. Then the court held as since the issue involves alleged illegal issuance of permit, we do not think, the question of limitation is very important here. Stop. This is so because an illegal permit continues to remain an illegal permit and no amount.
Well, I have not been that judgment. I have not. You could not deal with this. Mala, your loss of kindness, my lord. Your loss of you're recording all these things, my lord. Then I may not get any justice there. Mala, kindly see, my lord. Mala, but your lordship is recording that fact. Mala, your lordship observing from quoting that judgment.
Okay, that.
No, I'm not on that. Let me have a chance to go through the judgment. তুমি ছিলে তাহলে তো এখানে তুমি ছিলে
And no amount of.
ও পার্টি ছিল ওই যে এনাই খান
Can for this illegal.
উত্তেজিত হচ্ছে না রেগে যাচ্ছে
অমল কুমার সেন তুমি কার হয়েছিল
এই অন্য সেন
স্টেট রেসপন্ডেন্ট
মানে আমার বিল্ডিং এর চেম্বার
in that case NI can lost the matter. In that case NI can lost the matter. And yes, my lord.
I'm on the delay only. I'm not very set on.
My lord, your lordship recording, my lord.
Upon submission of the please.
My lord, I'm denying my lord, allegations. My lord, your lordship, the allegations I'm not admitting, my lord.
Putting the allegation at all. I'm just asking the authority to consider the representation. That's all.
Representative means he paid for cancellation.
Yes, the authority will consider.
My lord, who is he? My lord, I am asking myself. Can he do so? I'm asking my lord. In my, anybody can challenge.
Shamata, I'm
No, এটা কি হলো? না, এটা আমার. Anybody can come. আমি বলার সুযোগ পেয়ে দেবো কথা আমি বলার সুযোগ পেয়ে দেবো কথা আমাকে বলার সুযোগ আমি কিন্তু বলতে আমাকে তো বলার রাইট আছে একটা
এটাই তো হচ্ছে
that since the petitioner has alleged fraud practiced upon the authority by the private respondent, the concerned authority upon the by the private respondent, filing the petition is irrelevant. Petition is. Who should consider the representation? The registering authority, who should consider?
Registering the Howrah.
Registering authority how? Yeah, registering authority. And my lord, in course of such, my lord, consideration, This number 5. My lord, kindly, my lord, give my lord liberty to the registering authority, my lord, to call for any record or any document from any other authority.
He already has the liberty.
My lord, kindly, otherwise, my lord, maybe because it is my lord, other state, kindly consider. So that power, that liberty of power limit, I think for the purpose of proper adjudication. Because he said that the Bihar authority is also involved, so that is.
Dispose of direct to the fifth respondent to consider and dispose of the.
Respect 5 or no? Is it respect 2?
Regional Transport Authority, how?
Yes, they are the, which has granted the permit.
This is it. 2, 3, 4. Who is the authority?
কে করবে রেজিস্ট্রিং অথরিটি
Registering authority, not.
রেজিস্ট্রিং অথরিটি গ্রান্ট
Registering authority.
regarding the registration but regarding the grant of permit regional transport authority.
He's asking for cancellation of both permit and registration.
That is the subsequent. First of all, whether the registration, my lord, that is based on fraud or.
Registration goes, permit also goes.
That is the subsequent,
So
the consequential matter.
Directed to consider and dispose of the petition submitted by the petitioner dated such and such, 14 June 2023.
কি করবে তাহলে? মানে respond of 5.
Within 6 weeks?
5, yes.
Within 6 weeks from the date of communication of this order, upon affording reason.
No, my lord, within 8 weeks, because my lord, if the documents they my lord, required to my lord,
8
obtain.
weeks from the date of communication of the order, upon affording step opportunity of hearing to all concerned, including the petitioners and the petitioner and the private respondent, in accordance with law. So the fifth respondent is at liberty to call for all relevant documents.
Yes.
In custody of the authorities, in respect of as well as outside, comma, if required, comma, for effective adjudication of the
Yes.
representation. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case and the authority shall be at liberty to deal with the representation independently and without being influenced by any observation which may have been made in this order.
Get a communication to me also. You lost a confine the communication to the
And the private respondent.
and representation. To the respondent number 7 or to the authorized representative. She is a lady.
Upon hearing both the parties, petitioner and the seventh respondent / her authorized representative. এটা যাবে ওইখানে আর করার দরকার নেই। পরে যেখানে বলে can be served upon খালি হিয়ারিং এর yes next line
এটাই তো খাপাচ্ছ শুক্রবার দিনকে ওরে ভিড়টা কই রে
514.
I appear for the petitioner. Let the petitioner be.
yes
Now, my lord, the petitioner before your lordship, my lord, had entered into an agreement for leasing of parcels, my lord. That was for my lord Howrah to Jagodalpur through Samoleshwari Express. Though it is from Howrah, but my scheduled departure point was from Shalimar. Now, immediately after the entering into the agreement, two kind of problem I faced, my lord. One is that the scheduled departure time of the train was 10:20 p.m. in the night. Whereas I was allowed to load and unload to a midnight. That is 1 a.m. or 2 a.m. This is the time. So there was an excess time. There's a lot of time pending. Thereafter, they used to keep this vehicle pending there. And before they used to attach with the train. During this some course, at certain point of time, they missed the train. They have to carry from Shalimar to Howrah and then attach to the original train. And the rule says that I should be given an opportunity to load 3 hours free time. That should have been an nexus with the original time of departure. The provision which says that I shall be given 3 hours free time will appear if your lordship see page 48 of the writ petition. Clause 10.2, my lord.
48.
48 of the writ petition. Now, my lord, the contractor should complete the loading and uploading operation within the available time at originating and destination station after placement of rake at originating station and before removal of rake at the destination train. 2.1, 3 hours free time at the from the time at which the parcel van vehicle is placed in position shall be allowed for loading and unloading of parcel case in case of leased parcel van is placed in a separate terminal at originating and destination station. Now, my lord knows, my lord, Shalimar has a separate terminal. Now, therefore, my lord, the parcel van was placed there. But it was used to be placed at 1 a.m. in the evening, whereas, my lord, the departure is 10 p.m. There is a gap of more than, my lord, 10 to 12 hours. I wrote them later, my lord, that it should be, my lord, there has to be a nexus. 10:20 if the departure time, I should be given a time when after 3 hours you can take it, but not 12 hours. And, my lord, in this entire course, 3 or 4 of my vehicle could not have been attached. So if today's parcel van is not attached, my lord, it is kept pending. I'll have to pay for the next day even, but I will not be allowed to use, my lord, the next day's place because that parcel, the previous day parcel will go there. I have pleaded, my lord, this at paragraph 4 of my writ petition. In fact, if your lordship see, I have given in page 5, paragraph 4 starts from, my lord, page 3. I have given the detail of the problem I face.
Has the railways filed a report? on
Yes,
this?
my lord, they have.
Paragraph
4 of the writ petition starting from page 3, my lord. In A and B, I have given the two problem I faced. A is, my lord, that it was kept in 10:20 and, my lord, I was allowed to load at 1 to 2 a.m., and which is in violation of the circular. If I may read, my lord, the paragraph, your lordships want. My lord, the train originates from Howrah station. However, loading and unloading facilities were provided to the petitioner at Shalimar station in separate terminal. The scheduled departure time of the train is 10:20 p.m. on the night. However, the petitioner was provided with the empty parcel van during the odd hours of the day, that is the midnight at around 1 a.m. or 2 a.m. Thereafter, upon completion of loading, the parcel van was kept standing in broad daylight, where thereby causing perishable items loaded in the said parcel van to perish. The aforesaid action of the providing parcel van is in contrary to the FM Circular number 12 of 2022. The clause 10.2.1 provides the 3-hour time shall be provided for loading and unloading from the time a parcel van is loaded in the separate terminal, and such 3 hours free time shall have to have a nexus with the actual departure of the train. The railways cannot provide parcel van around 20 hours prior to the departure and allow the perishable goods to perish. And next, Miller, the second problem faced by the petition is that despite loading of parcel van in the odd hours, the railway failed and neglected to take the said parcel van to Howrah station for attaching the said parcel van in the train. And in such cases, the loaded parcel van kept in Shalimar station for attaching the same to the next day. The petitioner was required to pay freight charges on all day. However, due to the failure on the railways to attach the parcel van on the particular day, the petitioner do not get any chance to load the consignment of the next day. Train, as loaded consignment of the prior date was attached to the train. These start causing financial loss to the petitioner. Chart indicating the date. Not the next date page, my lord, I have given a chart when the date, when the VP was not attached, and that since it was not attached, my lord, you'll kindly find the next date VP was not even placed. In these circumstances, my lord, there were 5 days. My lord, I have paid advance freight which was not utilized because the VP was not placed. I made, my lord, the representation to them that you need to look into these issues, my lord, otherwise it has become difficult for me. My representation starts from page 59, my lord. 22nd of May 2023 and I have given, my lord. My lord will kindly ignore the, my lord, the language of the letter, but it was that the same problem which I have indicated in the, my lord, paragraph 4 that has been written in page 22. And, my lord, it was followed by, my lord, on 29th of May, where we say that unless you give it to, my lord, solve the problem, we'll be unable to continue with it. And, my lord, it was continued till, my lord, 12th of June. If your lordship kindly see page 62, the last representation. While this representation was, my lord, filed but not considered, railway come up with, my lord, the termination letter at page 63. But this termination letter is under challenge before your lordship, and, my lord, pending after termination, they have issued a contract which has subsequently been stayed by your lordship. That issuance is also challenged. My lord, this termination letter, my lord, is dated 14 June 2023. My lord, the subject is termination of lease contract of 24-ton space in LVPH train number such and such due to sudden discontinuation of leasing operation from 27/5/2023. So, as well as deposition of lump sum freight due from the said service date. You will, my lord, did say you will lease 24-ton space in LVPH by train number 18005, 18006, Howrah Jagodalpuri Samoleshwari Express on round trip basis for a period of 19/4/2023 to 18/4/2025 at per round trip freight of 1,01,111 for 7 days in a week. You have suddenly discontinued the leasing operation from 27/5/2023. My lord, you kindly note the date. As well as lump sum freight also not deposited. So, my lord, according to them, I have not, my lord, utilized from 27th. This is their own case, my lord. Discontinuation of your contract is now treated as a breach of agreement under para 19 of FMC 1 2022, where it is illustrated that Para 19, payment of lump sum freight rent license fee by the contractor. Lump sum freight rent license fee along with GST sales, etc. at applicable shall be paid online through IREPS by the contractor. Amount and the time period will be allowed for depositing the lump sum freight rent license fee amount by the contractor will be as follows. It says leasing of parcel space daily or part trip basis at least 1 day prior to the day for the start of train, and the grace periods of maximum 7 days is given. If I don't pay, I can pay it a grace period. Now, the vital portion is, the second part. If the contractor, for the contract of leasing of parcel space, failed to pay the lump sum freight for 3 continuous days, he will not be permitted to load in the parcel space till and the pending dues are clear. And the railway shall have the right to utilize the parcel space as per its own requirement. The contractor shall however be required to deposit the lump sum freight for all the days, even if the space has been used fully or partially by the railway on some of the days for which the contractor was not permitted to load on account of non-payment of 3 continuous days. Paragraph 19.2, if the contractor fails to pay the full due amount as specified in 19.1, even after expiry of grace period, that is the 7 days, with penalty of 0.5% day on the delayed amount, the contractor shall be terminated and earnest money security deposit shall be forfeited without any further notice. And without invoking this clause, they terminate me. Now, if your lordship see the second part, it says that if the contractor fails to pay lump sum rate for 3 days, he will not be allowed to permit. So, it is not the railway's case that I did not pay but continued the loading. According to them, on 27th of May, I have stopped pay loading unloading operation. And I have document, if your lordship see, I have paid till 25th. So that will appear, page 70. I have paid till 25th.
I'm afraid you have to continue some other day.
I get it. Yes.
Come back after vacation.
Then my lord will kindly extend the.
Very short matter.
Yes.
Yes.
Kindly extend the interim order because it will expire on 20th.
Particular terms of the petition. Paragraph positive or time intervals. Paragraph let the matter appear under the same heading for further consideration on 19th January.
My lord.
And it will be extended till 31st.
Fine.
Paragraph the interim order granted earlier is extended to 31st January or until further notice.
Okay.